Good morning to all for our second of the three-day argument session in Philadelphia. Glad to have you with us. I typically do a very short statement of what we understand, or I understand the case is about, just to make sure that we're in agreement. Feel free to correct anything that I misstate. That's part of the reason I do it. And then, as our protocol sheet indicates, move to your arguments. We're a hot court. We know the facts. We know the issues. And we have a tentative take on where it is. But we want to hear from you to test our hypothesis and to make sure that our vote is correct at the end of the day. Mr. Siegel, you represent the appellant? My understanding is that the appellant's a police officer. He suffered a work-related injury when a drunk driver hit his patrol car. He received heart and lung benefits from his township. He then sued the drunk driver and recovered, and he brought separate Dram Shop Act against two tavern owners who served alcohol to the drunk driver while he was visibly intoxicated and prior to the accident. He settled with all the third parties. The township then sought subrogation for the monies it paid through heart and lung for the portion of the settlement paid by the tavern owners on the Dram Shop. The township argues that the Dram Shop Act claims do not arise from the use of a motor vehicle, and therefore subrogation against them is permissible. We granted aliquotter to decide whether the township's entitled to subrogation against the settlement from the taverns through the Dram Shop. So again, if that is substantially accurate, feel free to begin.
Yes, Mr. Chief Justice. May it please the court, Dan Siegel on behalf of Christopher Alpini. This case calls for this court to essentially address issues that were first addressed in Bushta and in the Sturmel case, and remarkably like the Sturmel case. But what is critical, particularly with regard to the briefs, is that appellants address this as a pure statutory analysis, which is how this court has addressed other similar cases, whereas appellees are looking at this more as a policy matter in terms of what is the policy. But this court does not need to go there, because the plain language of the Motor Vehicle Financial Responsibility Act talks about actions arising out of the maintenance and use of a motor vehicle. However, the distinction that needs to be drawn here is the question that was raised, particularly in Appellee's brief, as to whether the Dram Shop Act creates some separate exception, and it doesn't. And the reason that there's no exception is because when you look at Section 1705B, the tort options that are elected under the MVFRL, unlike the prior No-Fault Act, you have provisions that specifically say that the election is pursuant to applicable tort law. It does not limit the provisions of the MVFRL to only claims that arise purely, whatever that means, from the maintenance and use of a vehicle. This was ultimately from the maintenance and use of a vehicle, and that's where we start that analysis. With regard to this, when you look at the Act and you read the language together, both of the Dram Shop Act, the MVFRL, you have the Heart and Lung Act, and in light of all of those and the Statutory Construction Act, you see that the plain language of the Act does not require any additional interpretation. It doesn't require this court to make policy decisions or look at any sort of what are extra textual type of matters. The language of the Act is clear, and of particular relevance, Sturmel addressed a case in which there was a Dram Shop claim underlying, and this court's holding, which was affirmed in Bushta, very clearly affirmed that. But even more importantly is the fact that Sturmel was issued in 2014. This court wrote its opinion in Bushta in 2018, and the subrogation provisions of the Act were authored in 1990. The legislature had ample time, if it believed that there should have been a change in this court's interpretation, to act. And in fact, in the Dram Shop Act, which has been amended 43 times since its enactment, it was as most recently amended in November, on November 25th, 2020, and the amendments did not address the subrogation provisions. And when you head back then, using the Statutory Construction Act, you see that this court should, in fact, interpret the provisions. This accident ultimately occurred from the maintenance and use of a motor vehicle. And
your argument is regardless of the cause of action. And I'm having trouble, unusually, coming up with hypos as I sit here. But regardless of the cause of action, if the plaintiff is in a car, driving a car, that subsumes all, and subrogation is never permitted.
as to the Heart and Lung Act, yes, Mr. Chief Justice, that's...
Your argument, respectfully, is broader than that, as to anything, because you rely on the fact that he's a driver.
No,
You don't acknowledge, just use this case as the hypo, it's not the hypo, that the Dram Shop Act provides a completely separate cause of action against the tavern owners for serving alcohol, and it just happenstance that he's driving the car.
well, it's not happenstance. It's a situation in which the Act talks about the maintenance and use. And this claim, the matter we're here for today, does not come before this court because of a Dram Shop violation purely. You could have a Dram Shop violation that never results in a motor vehicle accident. Someone could get into a fight. They could, all types of scenarios. But the ultimate cause, just as the ultimate cause in Sturmel, wasn't the serving of the visibly intoxicated person. It was that person's subsequent act of driving the motor vehicle that led to all of this. And to correct a misperception in Aplt's brief, it was pleaded specifically in the complaint. The pleadings did subsume both of those claims. It's at page 160 and 170 of the record. But the ultimate cause is the maintenance and use of a motor vehicle. And it doesn't require this court to go beyond that to look back.
Excuse me, you can finish your answer.
I was done, Justice.
What concerns me, and I think in follow-up to the Chief Justice's question, if we allow this, then isn't there a multitude of other kinds of actions in addition to Dram Shop actions that could ultimately lead to a motor vehicle accident that would arguably then follow this same line of reasoning? How would we limit this to just Dram Shop actions?
I'm not suggesting that this court should. This court has to follow.
That's a pretty broad ruling then, isn't it?
No, not in the sense that it follows the pure language of the statute. Any determination where the court has to draw some line is not within the language of the statute. It's not within the language. The Dram Shop Act doesn't limit it. The Heart and Lung Act doesn't limit it. That's a decision that the legislature made, and most recently made it when they amended Section 1720 to allow subrogation with regard to workers' comp claims, but not Heart and Lung Act. And this court's role, and was particularly addressed in the Safe Auto case, is not to address policy issues when the plain language of the statute is clear. And that was the interpretation, that was the analysis in Sturmel, that's the analysis that Your Honor did in the Bushta case, and it follows logically. There's no need to try to interpret what other causes of action. We're here on whether, in this circumstance,
Counsel, may I follow through on your plain language of the statute argument?
Yes.
Then you would agree that based on 1722 in the Dram Shop Act, you cannot claim medical benefits or work loss?
Yes, because you wouldn't, and
well, you couldn't. I'm just asking to confirm that you're in agreement.
Yes.
So if you had to try this case, you would not put in any evidence of wage loss or medical benefits.
No, and in fact...
Yet you would not, is that
Yeah,
correct?
correct.
Okay.
I agree. And in fact, one of the issues that we address in the brief is the challenge, if not the almost practical impossibility, of what a trial court judge would have to do if, in fact, there was subrogation because of the dram shop claim, but not ultimately on the heart and lung. And how would you instruct a jury on medicals? What evidence would come in? What would be precluded? How would they weigh the evidence, reach a verdict?
But the statute answers the question. Where's the confusion? I mean, if you're proceeding under the notion that the recovery is not subrogable, then you cannot claim medical benefits or work loss in your jury trial case.
Yes, I agree.
Well, you agree, I'm not sure what you agree to. I think the point is, where is the subrogation claim at all?
There isn't.
If you are precluded from even seeking wage loss and medicals.
There is none, Justice.
So
In this
I'm
case,
not sure why we're here then. If you can't recover wage loss and medicals under the Dram Shop Act claim, then your right to subrogation under the Workers' Comp Act doesn't apply.
I agree.
So we don't need to interpret the anti-subrogation language of the statute.
No more than was done in Bushta or Sturmel. Those cases address this language, and the only nuance here that's different is that the grant of aliquotter in this case is based on the fact that there was the Dram Shop Act included within the issue. It wasn't addressed, it wasn't part of Bushta, and Sturmel wasn't decided by this court.
The appellee's argument is that this does not arise out of the use of a motor vehicle. That's the argument they're making. And you're saying, sure it is, because it was the motor vehicle incident that caused the injuries. There may have been illegal service of alcoholic beverages, but that in itself didn't result in the actual physical injuries in this case. It was the fact that that individual got into a motor vehicle and caused an accident.
Yes, and they also raise a policy issue as to whether that should be the policy, but there's no need for a policy determination here when the language is clear. And there...
Counsel, there is a need to interpret, and Justice Donoghue is dead on, whether this incident arose out of the maintenance or use of a motor vehicle. Another way to look at this, a legitimate way to look at it, in fact, every court that has looked at this, from the WCJ to the WCAB to the Commonwealth Court, has said this arose out of the illegal service of alcohol, and therefore it's a direct cause of action against taverns. And it did not arise out of the motor vehicle. And I appreciate, I don't know why I had a brain freeze on hypos. The guy walks out of the bar, he trips and falls, he's injured. The guy walks out of the bar and he gets into a fight and hurts somebody. The guy walks out of the bar and he shoots somebody. There's subrogation in all those circumstances against heart and lung, assuming he's a police officer, et cetera, et cetera. But he gets out and he gets in his car. And so, it's respectfully, it seems to me that it's a little bit of a layperson's analysis to say, well, that's obviously arising out of the maintenance and use of a motor vehicle. It's a more nuanced question. If it's arising out of that, or if that's just coincidental and it's arising out of the service of alcohol to an inebriated person. And I think that's the mountain you have to climb.
Well, I understand the point, but what you have here is essentially the causation connection. While the serving of the person visibly intoxicated led to him being inebriated, that in itself did not cause the accident. It was the driver's decision, whether, conscious or, in whatever state of mind he was in, to get into a vehicle and to use the vehicle. So that while there was an initial cause, which was the Dram Shop Act, if he had done any of those scenarios or more that we could think of, we're not here on subrogation. but it is then getting into the vehicle. And once he's in the vehicle, that triggers the obligations. Once you're operating a vehicle, this court's addressed that type of issue many times. And once he's operating the vehicle, you can't ignore or disregard the Motor Vehicle Financial Responsibility Law, which covers the issues of subrogation, covers medical benefits, including the priority in this case of what gets paid.
Does this serve the policies, and we're not driven by policy, but does this, if we hold for you, does it serve the
Policies of the Motor Vehicle Financial Responsibility Law when they put in the anti-subrogation provisions? You know, my understanding of that was, as much as I don't like it and I've written against it, to save automobile insurance carriers money. Here it's a dram shop insurer, and you know, we've not had a crisis of escalating rates on dram shop insurers. So is the policy behind this provision that you rely on arising out of maintenance use of a motor vehicle furthered by a holding for you?
Yes, it is, because the legislature makes those choices as to where those burdens shift. And when they enacted the subrogation provisions, they made the decision that it applied or relating to the Workers' Comp Act, not the Heart and Lung Act. When they enacted the tort options, they didn't do what was in the no-fault law. In the No-Fault Act, it talked about only injuries arising out of the maintenance or use of a vehicle. That was the tort threshold in the no-fault law in Section 103. They changed that language for the MVFRL, and that language is the consequence of the fault of another person pursuant to applicable tort law. It didn't say pursuant to the Motor Vehicle Financial Responsibility Law. So therefore, when they used broader language in the MVFRL than the old no-fault law, that was a choice that said other tort law. So the fact that the Dram Shop Act creates a tort cause of action, so could other laws, and they would also be subsumed based on the legislature's conscious choice to use that language and the fact that they've never amended it, whereas they've had the opportunity many times to amend, the MVFRL, the Heart and Lung Act.
And they didn't. After this court issued Oliver, they never amended the statute either as a result of that decision, dealing with carving heart and lung out from the workers' compensation cut through that was allowed. But I guess I'm wondering, though, Mr. Siegel, do the facts at all matter if we're focusing on the statutory language arising out of? Because these are insurance laws, and under statutory construction, we certainly apply the plain and ordinary language plain and ordinary meaning undefined language unless it has a term of art. Arising out of or arising out of a motor vehicle accident appears in policies all over the Commonwealth of Pennsylvania and is a term of art, which the General Assembly is very aware of. And I think our case law in Pennsylvania interprets that term of art as but-for causation. Am I missing something there?
No, and I just want to address, you talked about Oliver, but the legislature, General Assembly, is aware of this court's decisions because after the Probst decision, for example, they reenacted IRE provisions that were different. So they knew, they acted. They didn't act in this case. They made that conscious choice. And they had the decision in Bushta. They certainly were aware of Sturmel, and those cases came long before. So that's a consideration. And the arising out of the maintenance, that's not actually defined as a term in the MVFRL.
No, but it is a term of art in the insurance industry.
Correct. And it is no different than when this court looked at the continuum of operation of a vehicle in the Ballantyne case. It's the same type of thing. It looked at what was the plain and practical language. And if that driver in this case does not get behind the wheel of a car, we're not here. The fact that he was served and drove intoxicated created an additional cause of action, but we're not here absent his decision to operate the vehicle.
I think we understand your position.
Can I have a practical question. Theoretically, why does it matter to you? Because if we held that this is not a 1720 situation, then when you bring your Dram Shop Act, you can then claim medical expenses and wage loss. And arguably, your recovery will be increased accordingly. Am I right?
Yes.
And so there would be subrogation, but the recovery in the tort action would include that amount of money against which the subrogation is taking place. So I'm just trying to figure out in the real world why you care about this, your case aside, because, I mean, it presents a problem in a settlement, which is what you have. And we had another case before this court where our holding was based upon the fact that we couldn't break out the damages. Is that the problem, or help me with this? Why do you care?
That is a practical issue here, yes.
Is that why you care about this? Because I'm correct. If you brought a Dram Shop Act, regardless of 1720, you would claim wage loss and medical expenses for which your client was compensated through heart and lung or workers' comp. And so then, because you've claimed those dollars, the insurer for the tavern would then be able to subrogate against your amount of recovery. But you shouldn't lose anything in that mix because your claim was worth more because you made a claim for medical expenses and wage loss.
Yes, I would agree with that. But I can't, this court shouldn't disregard the practical issues that arise if this court finds that there is subrogation in it from the dram shop, because then you have these proof issues. How do you deal with what amounts are available, what aren't, and
So
the proof issues?
The answer to my question is you couldn't settle a case.
It would be a major challenge, I'll characterize it that way, unless there was limited coverage or something. But that's the practical difficulty, yes.
Is there any other reason?
Those are the practical from the day-to-day effects.
Well, we're talking about one reason.
Yes.
Okay.
Yes, what Justice Donahue had talked about, yes.
I think we understand your position. Thank you very much.
Thank you, Mr. Chief Justice.
Catchline?
May it please the court, my name is Chris Cackline. I represent AmTrust Insurance Company and its insured Tinicum Township and its police department in this matter. Mr. Chief Justice, I'm going to have to disagree with your facts a little bit, but I'll make it up with some of the hypotheticals that you may have been searching for. In every case where there's a work-related injury, workers' compensation benefits are payable provided that the injury occurs in the course and scope of employment. There are a limited subset of employees, police officers, firefighters, other enumerated employees in the Heart and Lung Act that are guaranteed their full salary if they have an injury in a smaller bucket of performance of duties. Okay, so every heart and lung injury is first a workers' compensation injury, every single one. In this case, the employer and its insurer issued a notice of compensation payable under the Workers' Compensation Act accepting liability, paid Officer Alpini $858 a week, and all of the medical benefits and all of the medical costs associated with the injury, which by the end of it was nearly $200,000. That was the workers' compensation payments. Then, Officer Alpini was brought up to the guarantee of full salary by Tinicum Township. But it's fundamentally important to remember that this is first a workers' compensation injury and second a heart and lung injury. Heart and lung benefits are not exclusive or exclusionary of workers' compensation. So even when looking at a motor vehicle accident claim, there's always a component part of the heart and lung benefit that's made up of a workers' compensation benefit. Always 100% of the time. In the thousands of cases that I've handled, I've never seen a heart and lung medical payment ever. It doesn't happen. It would be required that the township, whatever municipal entity, would have to pay that out of some extra fund that doesn't exist because those benefits have never been paid that way. And that's fundamentally important. Even in a motor vehicle claim, there's always a component workers' compensation case. Officer Alpini was paid these benefits until he settled his case. My client sought subrogation out of 2 awards, Dram Shop against Tavern 1, Dram Shop against Tavern 2. Those totaled $1.3 million. The motor vehicle claim was settled for $25,000. The exact reasons that some of the justices have discussed are the reasons why those recoveries were so discrepant. In a motor vehicle claim, no lost wages that are made up of workers' compensation and heart and lung are boardable as damages, no medical costs. It says it right in the Act. Because there's this preclusion on damages, there's a reciprocal preclusion of subrogation. If the plaintiff can't recover it, then he doesn't have to pay it back. Makes perfect sense. The Dram Shop recoveries were so much more because there is not that preclusion on damages. And we have we have the pleadings, we have the damages assessments.
Counsel, can I just stop you there?
Absolutely.
You don't know that. I mean, a Dram Shop Act could be worth more because a jury could be much more aggravated and concerned about the actions of a tavern under these circumstances. We also don't know what the insurance coverage was. The recovery could have been so much more because there was so much more, in the insurance coverage available. So I don't buy this notion. I mean, you're trying to create a symmetry that both of those settlements should have been the precise amount. I mean, obviously not.
Right, that's not exactly what I'm saying. The first tavern settled for much less, and the second tavern, which served a visibly intoxicated person very clearly, so it was $300,000 and $325 rather, and $975. What I was saying is we know that this is the case because we have all of the damage assessments from the third-party case. We have a pleading that pleads in the Dram Shop case from day one, from the date of the accident forward, all lost wages as economic damages. We also have pled all medical costs from the date of the accident forward as economic damages. In the Dram Shop cases only, not in the motor vehicle claim, because the preclusion of those damages was clear and statutory.
Well, that goes to my question as to what you could actually recover.
Sure.
And your opposing counsel is saying you can't recover the wage loss and the medical expenses. If that's the case, why do you care? I mean, as I read your brief, I mean, and it's based upon a basic tenet that I've never quite understood, but we have to, in any way possible, avoid double recovery. I don't know where that notion comes from, but that's clearly what your brief is asserting. But if your opposing counsel is correct, and I think he is, if he's arguing the statutory setup, the symmetry between 1720 and 1722, then they can't collect wage loss. They could not prove at trial and collect as an award wage loss or medical benefits.
That's true only for the motor vehicle claim.
No,
Not for the Dram Shop.
he's saying not.
Well, I know, but he's wrong.
But I think he's right. I mean, if he is correct that this arises out of the maintenance and use of a motor vehicle under 1720, then under 1722, regardless of whether you call it a Dram Shop Act or a motor vehicle accident, you cannot collect wage loss or medical benefits because of 1722.
Doesn't that require the court to superimpose the motor vehicle financial responsibility law on top of every other cause of action that could possibly be made? And these are Chief Justice's hypotheticals.
No, not at all.
It does.
Chief Justice's hypotheticals, in each of those hypotheticals, the visibly intoxicated person who was served falls outside or gets into a fight or any of those other hypotheticals. In each and every one of those cases, the victim can claim medical expenses and wage loss.
Correct.
Because it did not arise out of the maintenance and use of a motor vehicle.
The hypotheticals I was suggesting are the...
Counsel, just to follow up, your position, 'cause I think you're probably correct, so obviously this won't be 7-0. Your position is that you can recover them all because it doesn't arise from a motor vehicle act. It arises from serving a drunk patron.
That's right, that particular claim. And I think something Justice Todd touched on was other causes of action as well. Let's presume that Officer Alpini was in this motor vehicle accident He was hit by a driver who was not intoxicated, goes to the hospital, and has a botched surgery. Now, Officer Alpini's received benefits. Now he has a medical malpractice action. But because that motor vehicle was the initiator of the accident, which limits his recovery for the motor vehicle claim, you would also be saying that subrogation would be precluded against the medical
Well, but see, this is where this is sort of like, I'm sort of aligned with Justice Donahue in the way she's asking you these questions, is this is a case of heads you win, tails you win. If this action arises out, if we interpret arising out of a motor vehicle as but-for causation, which seems to be the precedent in Pennsylvania dealing with insurance policies interpreting that language, then this action arose out of a motor vehicle and you can't get subrogation. But under 1722, he can't recover under the dram shop law for what otherwise would have been paid under workers' comp law. Now, if it doesn't arise out of a motor vehicle, neither of those twos are operative and you get subrogation. So heads you win, tails you win.
I don't think so, Justice. I think what we're looking at is the individual claim. Did the claim against the motor vehicle policy arise out of the use or maintenance of a motor vehicle? Yes. Therefore, every 1720, 1722 apply. Did the dram shop recovery arise out of the use of a motor vehicle? No.
Well,
that guy could have hurt somebody any other way.
I agree. You're missing my, I don't know if I'm articulating my point well, but you're sort of missing my point. 1722 saves you and avoids a double recovery if we interpret the dram shop claim here as arising out of a use and operation of a motor vehicle accident.
Well, it doesn't particularly save my client any money because they're still paying workers' compensation. They're just never getting it back.
Because there's nobody you're recovering it from.
Correct.
There's nobody to recover it from.
Absolutely. I agree with you. And that's why that recovery, outside of the circumstances that Justice Donahue mentioned, that's why the motor vehicle recovery was $25,000, not $1.3 million.
So you want him to be able to recover it, and I see what you're saying.
I actually don't care either way. I just want
Well, you do because you're here.
To get its money back if he does recover.
Right. So what you do benefit from is if it doesn't fall within 1720 and 1722, your client has a chance of getting their money back.
Correct.
But if it does fall within 1720 and 1722, he's not making any claim for wage loss and medicals, and then your client's just out for what they owe under heart and lung and workers' comp.
Well, in this situation, workers' compensation, and that's one of the distinctions I tried to make.
But the scheme wasn't designed to give you a recovery of money. The scheme was designed to avoid a double recovery.
Correct. Among the other two elements of the equitable principles in subrogation. But it's also really important to remember that even if that's all true in the hypothetical proclamation of the law, in this case, Officer Alpini did recover for his medical benefits from the date of the accident forward. And he did recover because he pled those as economic damages. So let's presume the court proclaims that there is this anti-subrogation idea. He waived it by pleading as those damages. I mean, if the motor vehicle financial responsibility law lays over every other cause of action, common law or
Then he
statutory.
shouldn't have been able to recover those damages.
I agree, but he did.
But you don't know that. I mean,
Well-
that gets to the practical issue that we discussed at the end of your opposing counsel's argument. This case was settled.
Yes.
And I find it very hard to believe that the person negotiating on behalf of the taverns who had the ear of their insurance carrier didn't say, you can't recover those damages. You can't recover those damages. I know you pleaded it, but I mean, you're telling me you had $300,000 worth of, medical payments and work loss. We're discounting it because of the subrogation issue involved here. So, I mean, your hypothesis is he did in fact recover it, but we just don't know that.
Well, I think we do. I think we do. Because at the time of the settlement, he'd been out of work for about 3 years, and he had accumulated approximately $200,000 in medical care. We also have all of the pleadings and all of the damages, the expert reports from the economic damages assessment. We have all of that. We know that he was pursuing wage loss from the date of the accident forward and medical from the date of the accident forward. That was paid for by my client, and if he recovers on those ideas, which he almost certainly did to generate a $1.3 million settlement, that he should have to pay that back in a pro rata share to the non-negligent employer who paid for that up front. That's the entire concept of subrogation. So if he would have gone to trial, or let's presume it was an uninsured motorist and he didn't make a motor vehicle claim, would your assessment be different? If it was just the 2 dram shop cases, would the assessment change? If it was a medical malpractice case, does the assessment change?
In those situations, you don't have the overlay of 1720 and 1722. I mean, this is a very niche area that we're dealing with here.
It is.
I mean, and you know, the issue, and we had a case where the same thing came up. I mean, and we found in favor of the employee in that situation because it was unclear what was actually paid in the damages award. Now, once the law is clear, let's assume hypothetically that we have a 4-3 decision.
Well, we already have Justice Brobson acknowledging that he's aligned with Justice Donahue.
So, let's say we have a 4-3 decision. I mean, but the law is absolutely clear when this decision comes out that in this circumstance, when you have a Dram Shop Act violation that results in liability, because they don't. I mean, you could serve a visibly intoxicated person and have no liability, period, because nothing bad happens. But when you have a Dram Shop violation that results in liability because of a motor vehicle accident, nobody claims any wage loss or medical benefits, period. It would be the end of the discussion going forward forever in any of these kinds of cases. The reason we're here now is that there's apparently there is uncertainty as to what happens in these circumstances. But the decision by this court that in this circumstance, Dram Shop, motor vehicle accident, no subrogation, and no claim for wage loss and medical benefits, ended discussion. I mean, it's a clear law at that point.
I hope there are no plaintiffs' lawyers in the room because that's going to diminish settlements in every case.
That's why I asked him the question.
Right.
That's why I asked him the question. Why do you care? I mean, you know, does it diminish? It actually not. I mean, hypothetically, maybe yes, maybe no. But that's really, I asked him why he cared, but for our purposes, it doesn't really matter. I mean, if 1720 and 1722 working together preclude subrogation and
every case,
and
every other
recovery of those in a tort action, you should be happy. I mean, it's Justice Brobson's point. I mean, it's a win-win.
Well, again, it might be the proclamation of the court going forward, but it's never been before. It's never been, and that's why the damages were pled the way they were in this case for Officer Alpini, and I think we're going to have to disagree on whether or not he recovered on lost wages and medical.
Well, I think Justice Donahue's point is that you don't know. Now, I agree with you that if he pled them, and the amount of his recovery strongly suggests that there was a wage loss and medical component to the recovery, but I suppose non-economic damages could get to that amount. I think that's possible.
We have the expert's assessment, and they weren't even close.
Yeah, well, I mean, but
Is it in the record?
It's not in the record in the case below because it wasn't. Again, this
It's
issue.
in the settlement case, it's not in this.
This issue has never come up since 1935, the Heart and Lung Act, and since 1915, the Workers' Compensation Act. What I think Justice Donahue and Justice Brobson are suggesting has never come up. It's
well,
never been
before Oliver, workers' comp and heart and lung were treated pretty similarly when it came to these subrogation claims too.
Heart and lung, yes, but not workers' comp.
Well, workers' comp and heart and lung were marching in lockstep until the repeal of the subrogation language, and this court said, well, when they repealed it, up until that point, everybody felt workers' comp and heart and lung ran together. Yeah. Then this court in Oliver said, yeah, but with this repeal, it ran separately. So there's always time for new things.
There is, but again, I just like to reiterate that if the court wants to make a forward-looking decision that any time a motor vehicle accident is the basis of any other type of common law or statutory claim, therefore precluding damages and subrogation, that didn't happen here.
We don't know that. And I understand the point that you're making. See, we don't know about the taverns here. I mean, is this like the fourth or fifth dram shop liability claim against one of these taverns, so that, you know, they're sitting back and they're saying, we could really get banged on this one? You know, I mean, did that happen here? We don't know that. You know, and so I understand your point, and I understand, but the fact of the matter is we can't hypothesize why this case settled for what it did. Believe me, I feel your pain. I mean, I do, but...
If it walks like a duck, it's probably a duck.
May I ask you?
Absolutely.
I understand Justice Donohue and Justice Robson's tangential concerns of ramifications from 1720, 1722 on all of these things. I think I understand entirely, but I look at the case much more simply. I look at the case as to whether these dram shop acts or your medical malpractice action, which I think is a good hypo, arose out of the use of a motor vehicle. And if the answer is yes, then you don't prevail in a case. And the answer is no, that these are discrete causes of action for med mal, dram shop, whatever, assault and battery, if he shot somebody, then you prevail in a case. Now,
Right.
Is that how you see the case?
It is. I mean, there's, it's not a reported case, but there's a case of a negligent retention of an employee who was having seizures, driving a bus, hits a police officer in the performance of his duties. When that police officer sues the company who owns the bus for negligent retention of that employee and recovers, you're saying that that police officer, well, you're not. If it were to go a certain way,
Friends are. Go ahead.
you would be saying that that police officer couldn't plead economic damages of
Right.
lost wages and medical and would have a significantly reduced recovery from the actual negligent party. The most negligent, in that case, the only negligent party. Here we have two negligent taverns serving a person, and subrogation is meant to hold those negligent parties liable and repay an employer who covers a person's expenses until they can get that recovery from the actual negligent person. So if subrogation is disallowed, thereby...
Again, I'm interrupting you, and I intentionally. You're drifting into the consequential argument arising from the decision. I probably shouldn't use the word arising. I'm using the statutory word. But I'm not, I understand it, but I'm not sure that it's the case. I think the case is, and I'm trying to see if you agree with me or disagree with me. The case is whether or not these discrete, not to use any hypos at all, these discrete Dram Shop Act cases arose out of the use of a motor vehicle.
And it did not. It arose when the bartender poured the drink.
Well, the problem with your medical example, and I actually had that written down in my notes when I was thinking about this, is that that act of medical negligence didn't happen at the time the Dram Shop Act claim arose. It happened later on. This one, the Dram Shop Act liability, wasn't triggered by serving the the visibly intoxicated person. It was triggered when the visibly intoxicated person committed a tort on somebody.
Right. My hypothetical was a little bit different in that it was a non-intoxicated driver hits a police officer in the course or in the performance of his duties.
Right.
That police officer then has treatment under the Workers' Compensation Act, paid for by workers' compensation, and that medical treatment is negligent. He then sues, all deriving from the work injury, right? But there's a motor vehicle component because the person actually hit the police officer. The person wasn't drunk. So now the police officer has two causes of action, statutory. Motor vehicle financial responsibility law, cause of action for the negligent driver. And he has a separate medical malpractice claim.
Yeah, but from a I know I'm delaying this, Chief. From a but-for causation perspective, that might be more attenuated than what we're dealing with.
Why? The motor vehicle accident caused the back injury and the doctor messed up the back surgery.
Well, because you could argue, well, he got into the car. So his getting into the car was, you could but for that all the way out. There might have been there was an intervening event there being the medical negligence, but
Make it a non-intervening event.
The point being
He's
that
at
we
the ER.
understand the case.
yeah. But this is fun. I'm enjoying this.
We always have a good time.
We have a good time. Yes.
Is there anything you'd like to add? I do think we understand the case.
Not if the court doesn't have anything else. I appreciate the time.
Not that I don't like the criminal stuff, but this workers' comp stuff is great.
why I have
Thank you both. It was well argued by both sides.
Thank you.
Operating his motorcycle, and he was in an accident with an underinsured third-party motorist. The motorcycle,
Was insured by Progressive and did not provide UIM, underinsured motorists. I think we all understand that, UIM coverage. The appellant sought benefits from Erie Insurance under 2 other insurance policies, insuring vehicles driven by household members, for which he was an insured. Erie denied the claims, citing the household exclusion and contending that it barred coverage because the motorcycle was a household vehicle not insured under either of the Erie policies. In response, appellant argued the household exclusion was invalid as a de facto waiver of stacking in accordance with our decision in Gallagher versus Geico, and we accepted review to determine if Gallagher is applicable under these expanded facts, and therefore Mr. Mione would be entitled to UIM coverage under the Erie policies covering family automobiles. Again, Mr. Cooper, feel free to correct anything, and if not, explain the ramifications of Gallagher to us.
May it please the Court, Mr. Chief Justice, Madam Justices, Scott Cooper on behalf of the appellants Albert and Lisa Mione. I guess I'll start with the Chief Justice's favorite rubric, you get what you pay for. In this case...
But we're so simple.
If only. And now we're going to address the other part of the financial responsibility law. So if everyone's minds weren't blown on the first argument, now we're going to get on the second argument. In this case, what Mr. Mione did is pay for access to stacking. And he paid for a premium, and it comports with the Gallagher decision. In the Gallagher decision, everyone knows the basic facts that it was a de facto of inter-policy stacking. In this case, you look to the policy that they're bringing the claim under. Whether or not the motorcycle had coverage, did not have coverage, is of no importance when it comes to the stacking analysis.
How can that be? How can that be that it has no relevance? I mean, why does this case implicate stacking at all?
Well, Justice White, the reason it implicates stacking is and even if it doesn't implicate stacking, I'll explain why the Mione still should recover. But the reason it implicates stacking is it's an arithmetic. It's the sum of the limits under 1738 that a person's an insured. In this case, the sum of the limits, it's 0 plus 250 or 500, and it's the sum of the limits that they're insured under. That's where you get the stacking. And it's not just one, you have to have one on top of the other, because if that would happen, then basically, if he had 15,000 of under on the motorcycle, I'm sure Erie would still be arguing that he still should not be able to recover.
But in this case, he did not purchase UIM. The motorcycle was insured by Progressive, but you want to get the benefits from a different policy provided by a different carrier, Erie. So this seems to be a very different fact pattern from Gallagher. How do we extend Gallagher to this set of facts?
It's a different fact pattern, but it's the same statutory analysis that there is 17, under the Erie policy, there is underinsured motorist coverage that he purchased He did not waive, they took stacking. And because they took stacking, therefore, he's entitled to get the coverage. Now, there was another policy in the House, just to give an example of how he may not be able to get coverage. There was the single car in the House in this case. There was 2 cars on one where they had the stacking. There was a single car where I think it would be undetermined based on whether they're stacking or not because it's a single vehicle. But Erie's position is that there was a single car rejection of stacking. Under Donovan, he could not get that under that policy because he would have rejected inter-policy stacking.
Wait,
So
I'm confused by your answer. I'm sorry, just to try to clarify for me what you just said. Under the 2-car policy, he had stacking clearly. But under the 1-car policy, what did you say?
there was a 1-car policy in the House that the deck sheet says no stacking.
Right.
But because this was a judgment on,
Again, and I'm just trying to clarify, is that Allison's car or is that another car?
that's Angela's car.
Angela's car.
Angela's car was a single car.
But I thought you just said, which we can't determine whether it said no stacking. We can't determine as a matter of law whether stacking is going to apply or not apply, but we can determine that the policy said no stacking.
Correct.
Okay.
And because that's a single car, this is actually how this whole issue is kind of comes together between Gallagher and Donovan, that Donovan, where there was this single car policy with the rejection, in this case, if there is a single car rejection of stacking on the Angela car, then they may be able to use that, the exclusion in this case, because he rejected inter policy. In this case, on the Albert car, they took stacking. In addition, the reason why, let's assume this isn't a stacking case, because the amicus and the defense says this isn't stacking. The reason this still is required to provide coverage is because under 1733, he has to go to the car or the motorcycle he's occupying first. He's an insured under all three policies, but if it wasn't for 1733, he could go under any car he wants.
But he decided not to purchase UIM from Progressive for the motorcycle. So I'm still not following in either of those alternative scenarios how he gets to go to Erie and reach that coverage on a different vehicle. I mean, how is that even underwritten? How is that risk underwritten?
Because when Erie is writing the underinsured motorist coverage on the car, on that provision where he's purchasing it, they're not really looking at the other cars in the house. That goes all the way back to even before Gallagher. They only look at whether you purchase stacking or don't purchase stacking. And that would be more of a public policy decision. In this case, the statute, either under section 1733, he's an insured under 1733-2. 1733-1 is the one he's occupying under. If it wasn't for that, he could go under any car. They're trying to rewrite the definition of insured, which goes back to Gen Ret. Under 1738, he's entitled to the sum of the limits. And this goes all the way back to, even in our brief, we talk about Blumling and Williams and Bankus back in the 70s and 80s, that you cannot write a provision which conflicts and narrows the law.
Why would anybody spend the money to insure against the higher risk vehicle? If you prevail, then I guess people can just choose the cheaper option. We're going to have a lot of artful behavior then, right?
It possibly could happen, but in this
Mr.
case,
Cooper, may I follow up on Justice Weck? Because let's go back to my prime directive, you get what you pay for. Father goes out and buys a several $100,000 Mercedes, puts several $100,000 worth of liability insurance and then buys several $100,000 worth of UM and UIM on his Mercedes. Stacking follows because you've purchased UM, UIM. Now, wife and 9 kids all go out and buy other cars or motorcycles or rocket ships, and they all waive UM/UIM, but they've got the sugar dad's Mercedes, where they can all collect against that, and I think that's the hypo that Justice Wecht is doing.
Even if it's a different carrier.
Even if it's a different carrier. So, I mean, we do have language that you look at the policy under which he's applying. I acknowledge that, and it's something we have to deal with. But that's the hypo that I think Justice Wecht was concerned about, and it concerns me also.
And I agree, it is a concern, and it goes back to Eichelman. The thing about Eichelman, and this is where the insurance company could have protected itself.
Yes.
And this is why Gallagher applies, is Gallagher is saying,
Under Justice Wecht and my hypo, you win the war and you win the battle and lose the war, because it's not the household exclusion, arguably, that's limiting it. It's the inability to stack from a policy that doesn't have it. There's nothing to stack upon. But the hypo is the reason for that would undergird that decision.
Counsel-
I didn't want to interrupt you, but I want to make sure you're direct.
Before you answer, I'm not sure, you may have been done answering the question. Help me to see if I understand this. This is a problem that is addressable by, let's just say, Erie in this case. If in the application process they require disclosure of other automobiles in the household that are insured by other companies, so that when they do their underwriting, when they set their premium, they are aware of the fact that there is another automobile in the household that does not have a stacking provision in it. And consequently, the premium for the policies that have the UM/UMI coverage are adjusted accordingly. This is a problem that's a remedy is in control of the insurance carriers. Am I correct?
yes, Madam Justice Donahue. And also, it's not in the record, but Erie does ask these things, and it goes to a whole different exclusion, but they ask about other cars you drive that aren't even in the house. So we'll get to that in like 6 months.
I'm not sure. I appreciate Justice Donahue's question. I'm not sure that's how auto rate making actually works, because I think auto rate makings as a personal lines are still regulated by the insurance department, aren't they?
Yeah, they are.
So you can't individually underwrite based on how someone answers a question. You have to apply the rate structure that's approved by the Pennsylvania Insurance Department.
Correct, but in the, Justice Brobson, in the Erie underwriting and rating manual and rules manual, they don't ask any of this anyway. They don't even, when they're doing the stacking premium, they don't look at it. They're just looking at, is there stacking, is there not stacking? And one of the things, going back to Eichelman, which I was reading this morning, which is interesting, is Eichelman is basically the same facts. And that was decided on public policy. And it goes back to, I think I was bringing this up yesterday about law school. When you have the law, you argue the law. When you have the facts, you argue the facts. If you don't, you fall on public policy. And in this case, the law is what, the financial responsibility is what requires this exclusion to be set aside in this case. Now, in Eichelman, which is where I think everything went off the rails on consumer and overarching riding public policy, prior to Eichelman, exclusions were deemed invalid and presumed invalid, these types of exclusions. That's why they never came up until like Paler and things like that. The public policy is where everything started to go off the rails. But retired now, I guess, past Chief Justice Castile, when he wrote that opinion in Eichelman, he specifically says, we conclude that when household exclusion specifically says that you can't recover if the vehicle you're occupying is uninsured, it doesn't have the coverage, we're enforcing it. They don't say anything about Well, what if there was 15,000? In this case, Erie could have easily written an exclusion, because I've seen it in ISO and 21st Century, I've had it in cases where it says, we will not provide coverage when you are occupying a vehicle that you own that's not insured for that similar coverage. So they could have written it in a way, in this case, it's just saying under this policy. So it's really, they're not writing it to say, you have to have some coverage, because in those cases, before Gallagher, I used to, you look for the rejection form and stuff. If the client rejected it, a lot of times people would just need to get any coverage in order to then implicate the second policy. So that's why it's really, so then to take Chief Justice Baer's hypothetical, Erie would still be here saying that it's not right, assuming you had the sugar daddy, if I got, with the gajillion dollars, and the 9 kids, and they decided to insure 9 vehicles for $15,000 of uninsured, underinsured motorist coverage. They'd be saying, well, now you've only done 15,000, but now you want to get $1 million. There's really, I believe it's a distinction without a difference, and this is really more a legal issue as opposed to a public policy. If this was a pure public policy, maybe, but this is an Eichelman language right at the end specifically says this would be valid, but if it said uninsured, you have to have something on the other car, and that's not what this exclusion says.
I think it's a very difficult case, and just to expound it, what if rather than jumping on his motorcycle, he's a passenger in another car or he's a pedestrian? Then I think he probably can go against the UIM in the Erie policies where he gets on his motorcycle, and again, that's what we're exploring. I want to ask you the most basic of questions that you would think I would have known for the last 50 years. Where does the word stacking come from, if you know?
I looked it up yesterday, and it's basically a term of art of adding coverages together.
And again, I think this is where Justice Wecht was at the very outset. And I thought the argument was somewhat attractive, but again, it sent my mind spinning on all of this. If you don't have UIM on your motorcycle, is there anything to stack upon?
Well, you're really not stacking. You're doing the sum of the limits, which is from 1738. And it also, I still think, Chief Justice Barrett, goes back to Gen Ret, because this could be a priority of coverage as well. That if you're not having stacking, let's assume he was on the friend's motorcycle or something like that. We wouldn't even be, under 1733, we'd be in 1733 too, and like you said, no one would deny he's entitled to at least 500.
So it's really not about stacking at all then?
I think it is, but if the court was inclined, you could find it's a priority of coverage.
Well, that's why I'm asking. Because let's suppose Mione had waived stacking on his personal automobile policy, but he still had the UIM. And suppose there was no household vehicle exclusion in the policy. Would he be entitled to UIM benefits?
If he waived on the 2 cars,
Yeah.
and he was a passenger,
Yeah.
he may be because of Donovan.
So then it's really not about stacking, right?
It may not. That's the whole point of this. Is it's really Gen Ret. You could rule either way. It really.
I think the problem is the policy.
I think it goes back to justice. It's heads we win, tails we win, but for
it's the
bad set of facts.
It's the primary policy coverage that's the problem.
Right.
The policy that the statute gives primary effect to is the motorcycle policy. And that policy does not have UIM because it was waived. And the question then becomes, because of that waiver on the primary policy that the statute as a whole has you look at first, doesn't have the coverage, are you unable to take the benefit of 1738A?
Right.
That's really what it is. When it says one or more policies providing UM or UIM coverage, does that one or more policies have to include the first in line responsible policy? If it does, you're out of luck. If it doesn't, you can stack.
Correct. And the reason why this potentially could be both priority of coverage and stacking is, let's say you have the situation where now you're in that three-car thing that we were just talking about. If it's priority of coverage, he wins. But now, potentially on one car, there's no stacking. There's two cars with stacking. Then you have the other insurance clause, and it's a whole bunch of other issues that come into play.
Mr. Cooper, as your time draws nigh, it occurs to me that this whole argument has never mentioned the household exclusion and whether Gallagher should be expanded to fit this scenario or limited to its facts. That is actually the issue we granted upon. Now, you can affirm on any basis, but you may want to discuss that before you sit down.
Sure. I think Gallagher says this exclusion is invalid, end of story. Gallagher saying the household exclusion, this was the same exclusion in Gallagher that is in this case, that exclusion is invalid, and it's a matter of law, not public policy, whether it's a fair outcome or unfair outcome. This exclusion is invalid. If they would have written it in the way that I would suggest in the 21st century or something, then we may have a different story.
But there he had purchased. In Gallagher, he had purchased the coverage.
And in this case, they purchased the coverage.
In this case, there are two different carriers. In that case, Geico was on both, and the majority decided Geico had reason to know about the risk, right? Here, how does Progressive, which had offered coverage that he had declined to purchase from them, how is Erie to know that this coverage is available, that it should be covering something he declined to purchase?
Well, then it goes back to what Justice Donahue mentioned about underwriting, and if they ask the question, we don't know. This was all based on a judgment on the pleadings. And
People buy new vehicles and changes occur. So how is that sort of unknown risk to be underwritten?
because it goes back to the other cases prior to Gallagher, where we put in the record, companies knew about the other policies, and the agents knew about other policies, and they still enforced the exclusion. The exclusion would be there one way or the other, even if it was the same company in this case. This is just a bad set of facts for us, to be honest with you.
And I'm not sure I see this as an exclusion issue. To me, it just comes down to whether the stacking statute applies. I'm not sure it applies. I'm not sure in the absence of something to stack on top of.
I think personally it's priority of coverage.
I do too. I think it's a priority of coverage case. I agree with you.
And Gen Ret really applies.
And your argument, as Justice Brobson pointed out to you, is that the insurance industry does this in accordance with the law of big numbers and rates set by the insurance commissioner. And it's not as if they assign a different rate to Mr. A, Mr. B, and Mr. C, depending on some sort of unique circumstances.
Correct. If I buy stacking $50,000 or $100,000, I'm going to pay this premium. If Justice Brobson buys stacking, same amount, he's going to pay the same premium, like on the stacking. It's just, and the reason why Gallagher does apply also is because Gallagher stands for the proposition that the company, just like in Gen Ret, cannot write a policy provision that impermissibly narrows and conflicts with the mandates of the law, whether they agree with it or not.
I think we understand your case.
I'm sorry.
Still more questions?
That
Sure.
last part, I'm sorry, Chief. So what's your view then about how Erie ran afoul of that? What you just said about how they wrote a policy then that I guess intentionally narrowed scenarios unknown to them, where he went out and got a motorcycle, insured it with Progressive, and declined the UIM. So how did they drop a policy to avoid risk on that?
because they've written a policy provision that's going to not deny access to its insured that under 1733B or 2 mandates that any person who's an insured under the policy shall recover. It takes, whether it's, it may not be a stacking case, but the provisions are, and the law that the courts followed through, is you can't write a policy provision that runs afoul of the financial responsibility law, even if it may at one time comported with public policy. It's just invalid.
Thank you very much. Pronounce your last name for me.
Shikhanov, Your Honor.
Shikhanov, thank you very much. Please feel free to proceed.
Thank you, Your Honors. May it please the court, Glenn Shikhanov for Aplt Erie Insurance Exchange. Your Honors, what Justice Robson and Justice Weck pointed out is precisely what this case is about. This is a statutory violation case. The exclusion applies to the facts, that's undisputed. There's no ambiguity argument here. And what Mr. Cooper argued is it may or may not be a stacking violation. If it's not, that ends the case. That is the only provision that was argued at the Superior Court level. That's the only provision that was briefed at this level. So Section 1730 was actually never briefed before this court at all by the appellants.
What section was not briefed?
Section 1733. That argument that Mr. Cooper made was never briefed before this court or the Superior Court for that matter. So it's a simple analysis of stacking either applies or it doesn't apply. And to see whether it applies, we look to the language of Section 1738. Now, during appellant's argument, he actually cut off half of the stacking section. He said that some of the limits as to one or more policies is how stacking is defined. That's actually not true. What the stacking statute states is the sum of the limit as to one or more policies that provide UIM coverage, and that's dispositive to this appeal.
And where does that definition come from?
Section 1738A, Your Honor.
1738A, okay, thank you.
In fact, Chief Justice, I'm glad you brought that up because I wanted to quote the Crawley versus State Farm decision from 2006 that Your Honor authored. You defined interpolicy stacking verbatim under that decision as follows: the stacking of limits on two or more separate policies. That doesn't exist in this case. We don't have UIM limits to stack on top of. He rejected those. Because the exclusion applies, unless the exclusion violates Section 1738 pursuant to Gallagher, it just bars recovery. That's the end of the case. And that section simply doesn't trigger because there is nothing to stack on top of.
Well, counsel, that goes to statutory construction arguments, which is where I'm most comfortable. So the question really is, does the language one or more policies that include and UIM in the statutory language require the primary policy to have UIM?
It does, Your Honor, specifically because the one or more policies, the one portion of that is speaking to intra-policy stacking. And even according to this court in Donovan from last year, intra-policy stacking is not in play when it comes to analyzing the validity of the household exclusion. According to Donovan, Gallagher, as well as the appellant's brief, we're here dealing with inter-policy stacking, which is the two or more, or one or more policies. So if you have multiple policies, they need to provide UIM, and at that point you stack one on top of the other.
So you basically have to take, so in your view, well, I guess I'm not sure you answered the question. Here you have one or more policies under the factual scenario. You have the motorcycle policy, you have the one auto policy, and I guess the second auto policy, but that may not be in play. Those are your one or more policies, right?
That's correct.
But the one of the one or more has a waiver of UIM. So under Mr. Cooper's theory, that doesn't matter. You just set that one aside and you get the or more, whatever the or more say. Your argument, I think, is, oh no, if the one doesn't have it, you don't get the or more.
You don't have multiple that provide UIM coverage, and therefore you're not combining UIM coverage under multiple policies.
Well, you do, because I said there are three policies. So assume the third one also has UIM. So you have one, meaning the primary, and then you have another two policies in the household that provide UIM. The one, the primary under the statute, does not have it. That goes away. Can you still recover under the two, or in order for you to get stacking, does the primary have to have UIM?
The primary has to have UM/UIM in order for you to stack on top of. And
So for stacking to happen, just so I understand your argument, stacking has to go on top of the primary. If there is no primary, you can't stack.
Exactly, and it's the best analogy, I think, in practical terms is library books. You have a stack of books. Putting one book on a shelf, empty shelf, doesn't create a stack. We don't even have to look at case law, we can just look at Webster's dictionary. Putting one book on top of another on a shelf, that's what creates a stack. What you'll note, Your Honor, to your point about having two of these household policies that were excluded in the household, the Eichelman case, which is at issue, obviously, in this appeal, Eichelman also had two policies in the household. And Eichelman had the household exclusion, which this court applied. And in Eichelman, what this court said is, if we don't apply the exclusion, it's effectively a disincentive to purchase insurance in Pennsylvania. Every insurance carrier that issues a policy for a single vehicle may also be insuring another 99 in the household. Every insured in Pennsylvania will never seek to insure more than a single vehicle. It would just be a waste of money. And that argument, the policy argument, goes further in this case because we have a motorcycle that's involved. As this court is well aware, motorcycles are significantly more risky to drive. They have an inherent higher level of risk, more injuries, higher fatality rates. If the appellants are correct, Your Honor, no motorcycle will ever be insured again in Pennsylvania. Why would you ever pay the increased premium when you can insure a single safe vehicle in the household, own 99 other motorcycles, and get the UIM coverage for free?
May I ask you two things? First of all, you're not relying on the household exclusion. You're relying on the argument that there's nothing to stack upon.
No, Your Honor, I am relying on the household exclusion. It's up to appellants to convince this court how it violates the provisions of the MVFRL in this case.
Assume for a second that we intended to, or in the next case, extend Gallagher and say household exclusions are de facto waivers of the UM/UIM, which the legislature wanted you to have, so Gallagher's extended. Under your argument, don't you prevail in any event on the argument that there's nothing to stack on?
Well, Your Honor, if there's nothing to stack on, the waiver could certainly serve in and of itself to bar recovery. But, Your Honor, in the Donovan decision in 2021, this court actually rejected broadening Gallagher in the way that Mr. Cooper suggests. Mr. Cooper suggests that Gallagher essentially invalidated exclusions in Pennsylvania, the household exclusion as a whole. But that's not true, and we can look at Donovan to see that. What Donovan said is, instead of explaining in a single sentence, household exclusions in Pennsylvania are invalid, cite Gallagher. This court spent 5 paragraphs explaining that under Gallagher, it's not that the household exclusion is invalid, it's that the household exclusion cannot serve to preclude the claimant's ability to inter-policy stack benefits from the household policy on top of the benefits recovered on the host vehicle policy.
So in other words, you would limit Gallagher to its facts.
Exactly, Your Honor. And this court actually did that in Gallagher, too. The holding starts with, under the facts of this case, the household exclusion cannot serve to preclude recovery of inter-policy stacking. To Justice Wecht's and Justice Brobson's point, stacking doesn't apply in this case.
So, counsel, what happens, hypothetically, if Mr. Mione buys $15,000 worth of UM and UIM on his motorcycle?
Well, Your Honor, in that case, he would get recovery. And there's 2 reasons for that. One statutory and one it being as a matter of policy. The statutory reason is at that point, Section 1738 would trigger. And the stacking concept would apply, and the exclusion consistent with Gallagher would be unable to preclude recovery. But more importantly, Your Honor, there's a policy element to this, and Mr. Cooper obviously uses the extreme analogy of fatality with $15,000 underlying. For every one of those cases, there's going to be 10 wrist sprains where the household policy is never ever going to pay a dime, even if it has stacking, even if it's being stacked. When you purchase inter-policy stacking, you're not insuring the vehicle you're in as a primary source of recovery. Instead, what you're doing is you're purchasing exactly what it sounds like, the right to stack on top of other benefits. And what the insurer is getting in exchange for that reduced premium is insulation from ever having to pay from the first dollar figure. What that means is they know that there's another policy underneath that's going to cover the injuries, whether it's $15,000 or whether it's $1 million. And then and only then will the household policy be stacked on top of it. Maybe in the insurance world, the best analogy is umbrella policies.
But what you're saying is, if I understand you correctly, it's bad public policy if we go one way and encourage motorcyclists to never insure their motorcycles, but it's okay if we do it another way and motorcyclists can all buy minimal insurance and that's okay with you.
Well, Your Honor, I would certainly always advocate for maximum insurance.
Of course, of course.
Your Honor, in my household, my wife often makes fun of me for the amount of insurance I want to buy as related to both coverages and
You're a good Erie attorney. But
Absolutely. But with that said, Your Honor,
it seems to me you're slicing it pretty thin to say public policy good, public policy bad.
oh, Your Honor, the reason there is, it's not that I'm advocating for $15,000 minimal coverage, but if the coverage existed, that would trigger the requirements of 1738.
It's not that you want to make that concession, but that Gallagher forces you to, right?
That's entirely right. And Your Honor, Justice...
And I seem to remember a dissent in Gallagher that warned about this sort of thing. Am I right?
That is exactly what I was going to say.
I seem to remember my joinder of Chief Justice Baer, so.
Counsel, can I just ask one very quick question?
Absolutely.
Did Eichelman consider Section 1738?
Your Honor, Eichelman did not discuss 1738
Isn't that the entire ball of wax here?
Well, no, Your Honor. The reason Eichelman doesn't discuss 1738 is the same reason it didn't discuss whether there was collision coverage or what the limited tort election was. It's because it simply doesn't apply. So there was no reason to ever analyze Section 1738, either in Eichelman.
Was it argued?
Was
1738 argued?
No, because the claimant realized that stacking never applied.
Well-
And so there was nothing to analyze. And that was the same in Windrum and the Eichelman case.
May I ask you, he is an insured under all three policies. That's not in dispute.
That's correct.
And we have language sort of like that you look at the policy under which he applies, and that would intimate that he has some flexibility as an insured to apply under the Erie policy or policies, notwithstanding its failure to purchase under Progressive. And that would take you into Mr. Cooper's argument on this is not so easy as stacking. This is a priority of policies, and he has some rights as an insured under all of these policies. So how do you respond to that?
Well, Your Honor, it goes back effectively to Contracts 101. Mr. Cooper and I both took it, him probably a little bit earlier than I did, but we both remember the same refrain from Contracts 101. You get what you pay for, words have meanings, and you have a duty to read. Every policy, including these Erie policies, has the household exclusion in it, which affirmatively advise the insured that they're not getting benefits while occupying those other household vehicles. When they're buying a contract, it's not unfettered or unlimited coverage. It's coverage consistent with the terms and provisions of the policy which you're actually purchasing. So there are numerous scenarios where he gets recovery: when he's occupying his own vehicles, when he's a pedestrian, when he's in a friend's vehicle, when he's coming home in a taxi from a restaurant, and really the list goes on and on and on. But the exclusions do serve to limit certain risks, such as the risk of having 100 uninsured vehicles in the household, insuring one of them, and then receiving free coverage for the other 99.
Same question precisely. Priority of insurance coverage, plaintiff's right to, the court's verbiage that plaintiff has a right to apply under the policy he so chooses as an insured, and here he chooses to that. And couple that we read Gallagher, over dissent, as completely nullifying household exclusion. Because your response to my question was, well, household exclusion kicks in. If you don't have a household exclusion, how do you respond?
Your Honor, this is a household exclusion case. Certainly, if you read Gallagher to simply state that regardless of precedent, we are overturning the idea of household exclusion in Pennsylvania as a whole, this ends the case. And I'll have to, over dissent of Justice Wecht.
Which means it's not so narrow. The majority emphasized it was a narrow decision, right, in the discrete one, didn't it?
I do remember that as well, Your Honor. I have cited that portion in a few of my briefs. But Your Honor, the reality is when Justice Wecht's dissent in Gallagher questioned whether the Gallagher decision specifically overturned any precedent regarding the household exclusion, this majority spent 5 paragraphs explaining that it did not. Justice Wecht pointed out that the Ayers and the Baker decisions he believed to be majority opinions, and this court said those were plurality opinions, and thus that does not disturb precedent. With that said, Your Honor, the Windrum and the Eichelman decisions from this court were unanimous. They were a 1994 and 1998 decision. They upheld the household exclusion under materially identical facts. Gallagher did not overturn those decisions, and the holding expressly stated that it did not. Donovan only confirmed this. Again, Donovan could have just said, we overturned the household exclusion, doesn't exist. Instead, this court again analyzed, did the exclusion violate 1738 under those facts?
And this is, I think, my final question. And again, it's a very interesting, difficult case. I don't know that I would have made the admission that you did or the agreement that you did that but for the household exclusion, you lose the case. Because I would have thought that the argument was still viable, that there was nothing to stack upon, and that therefore, regardless of household exclusion, because there's no UM/UIM on the motorcycle, there's nothing to stack upon under these facts. What am I missing?
Your Honor, given that we have to go into the policy language, if there was no household exclusion, Mr. Mione would simply recover as a you or anyone we protect under the policy.
I see.
So coverage would actually trigger, and it wouldn't be excluded anymore because the exclusion would be gone.
Because he gets to choose the policy that he wants to apply under as an insured.
He's
the
an
priority of policy.
That's correct. He's insured under the policy, and under a number of circumstances I earlier mentioned, if the exclusion doesn't trigger, he would get them. In this case, it does, and it doesn't violate the statute. Therefore, it should bar recovery.
Well, and that's your point. That's your point is there's no the argument is this exclusion in this circumstance violates 1738. And your answer to that is no, the exclusion is fine here because denying him stacking under these circumstances does not violate 1738.
That is entirely right, Your Honor. Essentially, you have to look to this claimant under these facts. And what the appellants are trying to do is they're trying to basically say, look at Gallagher. Gallagher is a different claimant with a different fact pattern in that case. Under that case, Section 1738 was violated. Under this case, it is not. And the one thing I did want to point out to the math analogy that appellant's counsel made about 0 plus 250, the reason that analogy doesn't work is because there's no statute governing math equations. You can input any variable you like, whether it's a positive, negative, or a 0. In this case, we have a statute that says you can only use variables, policies, that provide UM/UIM. So 0 is simply not a valid variable. If we were to use one of those calculators that the kids use to give them their answer, the math calculator, so they don't have to learn math, it would just say invalid if you use that analogy.
I think we understand your case. Justice Todd has one last comment.
I just wanted to propose, Chief Justice, that we, in light of the fine arguments made by Mr. Cooper and Mr. Shikanoff, that we allow continuing legal education credit on insurance coverage to all of the attorneys in the room today.
Well, it's CJE for us, so thank you both.
Thank you both.
Thank you so much, Your Honors.
going to do it off the top of my head.
In this discretionary appeal, we consider whether the Superior Court erred in vacating a judgment of sentence based upon its then very recent decision in Commonwealth versus Chitskin, which held that a section of the Vehicle Code was unconstitutional under the U.S. Supreme Court case of a lien insofar as to define the prior acceptance of ARD in a DUI case as a prior offense, and I would actually characterize it as a prior conviction to conform with the lien language for sentencing enhancement purposes. Assuming that's correct, please explain where the Superior Court went wrong.
May it please the Court, Matt Metzger here for the Commonwealth. Good morning, Chief Justice, Justices. This is a case squarely evaluating the statutory section 3806 that allows
Will you pull the microphone a little closer? We're old.
Just turn
Yes,
it.
Your
No,
Honor.
you
turn
put
it
it down.
toward
Get it up a little bit.
you and turn it towards you. Yeah, pull it up and turn it towards you. There you go.
Better?
That's great. Thank you.
All right, thank you. Yes, Your Honor, it's about Section 3806, which allows ARD acceptance to be treated as a prior offense, analogous language, prior conviction for the purposes of subsequent prosecution when there is another conviction down the road on another DUI offense that occurs within 10 years. If it is a prior conviction, it can go under an exception, not a lien, for enhancing this mandatory minimum, but a line of cases that has lasted for a long time. Almendarez-Torres was the federal case. It was recognized in Pennsylvania as a Ponte, and can be presented directly to a judge at the time of sentencing as an objective fact that the judge can rely upon, as opposed to an Alene-style fact like whether somebody possessed a handgun or one of those enhancements that's just not factually objective. So historically in Pennsylvania, we've always treated it as an objective fact. It's been treated as such longer than I've been alive. The Wagner case back in 1986 said, for sentencing purposes, an ARD acceptance is treated the same as a conviction.
But how does, regardless of what's been done in the past, pre-Chitkin, where's the finding of guilt? I mean, doesn't there have to be, after Elaine, doesn't there have to be a finding of guilt for there to be a conviction?
There does not need to be a finding of guilt. It has to be an objective fact with adequate due process. It's a due process analysis. And there is adequate due process here because of the structure of how this was set up. There's nothing that indicates guilt is required. And there
Okay, well then, with respect to that due process, so of course with ARD, they're going to be told that if they mess up, well, there's the license, the costs, right? The drug and alcohol evaluation.
Sure.
What else is probation? I mean, are they told in your county that ARD will be used as a first offense, such that any subsequent
absolutely
one
they are.
will be a mandatory sentence?
And I know some counties may not operate that way, but Center County absolutely puts defendants on actual notice of that consequence.
It's in writing.
It's on the record. On the record, the judge indicates to them that it can be treated that way.
And that's part of the agreement in Center County?
Yeah, it's standard language in Center County. There are some cases that talk about how actual notice is not actually required, though. There's the Frost decision, I believe the Reed decision cited in our brief. And there's also just the standard language that folks are put on notice of what's in the law, and it is codified.
I lost you there.
I'm sorry, I'm backing away from the mic. There is, of course, case law that says folks are on notice of what's included in statutory and case law. And certainly it's not hard to look into the consequences of what comes with ARD acceptance.
Well, let's talk about this case.
Okay.
Well, if I may, can I just ask a question?
Sure.
What you just said there, are you indicating that based upon the practice of the individual county district attorney, if it's part of the record, due process is met and they are waiving their rights such that it may be used as a second subsequent, but in those counties that do not, it is not, it's an Elaine or an Almendarez issue?
I'm not drawing that distinction, no, Your Honor, because I don't need to. The Frost decision, the Reed decision says you don't need actual notice, that constructive notice is sufficient. It's very easy to find within the statutory
So
language.
what would be
of
the
case.
constructive notice if the district attorney doesn't provide that information on the record or through a written colloquy?
Because the case law has established that a defendant is on notice of case and statutory law. That's black letter law. So they are aware of that, at least constructively. And when they go through the...
Again, let's turn to this case. Looking at this record, the only thing before us is the record. In this record, did either the written, verbal, neither, both, inform him that by accepting the first ARD, it would be used as a prior offense?
I can't speak to that record because it was a 2015 ARD case. Our procedural posture was a little unusual on this case. Chichkin came out while we were already up on appeal on other matters. I think we had all just agreed at the time of sentencing that it was, on the face of the record, an ARD enhanced second offense DUI. So I can't tell you if he had actual notice here or not, because I don't think it matters under the black letter law that he's on constructive
I understand your argument on black letter law. I'm not sure I buy it. So I want to know if this is like a plea bargain, and we have lots of case law that a plea bargain is a contract, and if he agreed to this, then I think you have a very good waiver argument here. And if he didn't agree to it, I'm not sure your black letter argument flies. And what you're telling me is this record does not prove conclusively that he agreed to anything.
Yes, I can't tell you that this record shows that there was actual notice in this specific case.
And that is important because in my understanding from reading these briefs is that there's no indication that Verbeck was told, correct me if I'm wrong, that Verbeck was told that that ARD will be used as a first offense. That, in other words, that any subsequent DUI would lead to the mandatory. This is pretty critical. It is critical, right? Because it goes to whether these deals are going to be made.
So the way the practice was done before we were put on notice in Chichkin that things had changed is we would look in our records, we would have a repository in the district attorney's office that would say this person had an ARD in the past, and we would rely upon that. The defense bar relied upon that, we relied upon that, and those records don't indicate whether there was actual notice. I wasn't in Center County back in 2015, so I can't speak to the policy that was in place then. I can tell you that they've been doing actual notice the entire time that I've been.
Right, but maybe you weren't entitled to rely after Elaine. I mean, maybe Elaine should have conveyed to you that you weren't entitled to rely, and if that wasn't satisfactory, then just don't offer ARD to DUI offenders, right?
I think I'm pigeonholed by the constructive
Well,
notice.
I actually think what Justice Wecht is saying actually happened in some counties. Some counties' responses to Chichkin was to temporarily suspend approving DUIs in light of the Chichkin decision, which is sort of one of the reasons why we're here. But I want to go back to pre-Chichkin, which was his first DUI.
Yes.
Pre-Chichkin, the law in the Commonwealth of Pennsylvania, just as he was presumed to be aware of the law dealing with driving under the influence, nobody specifically gave him notice that you can't drive drunk. One construes he was constructively notified of that. The law pre-Chichkin said, according to the General Assembly, a prior offense is defined to include expressly ARD. Now, we may get hung up on this word conviction, but the reality of it is the General Assembly has the power to define the term orange to include a banana. And if the General Assembly defined it, then aren't all citizens of Pennsylvania who seek the grace of DUI from the prosecutor, or ARD from the prosecutor, presumed to know that the law means, hey, look, you have to stay clean for 10 years. And if you stay clean for 10 years, you're good. Otherwise, we'll prosecute you now and you'll suffer the penalty now.
Yes, absolutely. The General Assembly has that authority, and they exercise that authority. And it's not some hidden fact. This is not some backroom arrangement of which a criminal defendant is not going to be able to find this information. It's codified law. Any defense attorney worth their salt is going to be advising their client on this issue. And I think the Kahn decision that we briefed on talks extensively about we don't have to evaluate whether the General Assembly use the best mechanism that they could possibly use to get there. It just has to be one that's rationally related for substantive due process.
Well, that's all correct. I mean, that's certainly correct. But regardless of my esteemed colleague's banana example, the banana is not going to fly if it violates SCOTUS jurisprudence, right? So, I guess I still am not sure how you get over the Elaine hump here. If any factual determination that triggers a mandatory minimum has to be proven beyond a reasonable doubt, I don't see how the statute can fly. I don't see why Chichkin's wrong. I guess let me shut up and see how you answer that.
It's entirely under the Almendarez-Torres exception, this prior conviction line of case law. And the reason we can rely upon a prior conviction in that instance and just hand it to a judge at the time of sentencing is because it's an objective fact. It is the objective characterization. An ARD placement might not be a guilty plea colloquy, but it involves many of the same hallmarks. There's notice, an opportunity to be heard, it's in court, it's on the record, and you voluntarily agree to it. Those are what permits this to satisfy procedural due process under the Almendarez-Torres.
I have to interrupt you. I agree with Justice White entirely. I, with greatest respect, disagree with my esteemed colleague, Justice Robson. We get to say what's a conviction or not a conviction. You're not telling me if the legislature, in its infinite wisdom, would say, we're going to deem all arrest convictions for purposes of Alene and Apprendi, that flies, are you?
No, and I got the same question during the Meraz argument, and it makes good sense, but the difference between treating an arrest as a conviction and treating ARD acceptance as a conviction is the procedure that's involved.
All right, fair enough. So let's talk about ARD for 1 second.
Sure.
It's a pre-trial alternative disposition. The attraction to the defendant is you don't go to trial. You are not convicted. You are not found guilty. You are not sentenced. If you comply with the conditions of your ARD, and you'll tell me because it's been too long for me, but in 6 months or a year or 2 years at the end of ARD, your arrest record is expunged. Isn't that right?
That's accurate.
So it's a pre-trial alternative disposition as an alternative to being convicted and sentenced. So it seems respectfully an oxymoron to say it is a conviction.
So, of course, people go into it because they want to achieve that benefit at the end of not having a conviction on their record. It's a matter of grace the way this was set up. It is almost exclusively to the benefit of the defendant, with the one exception of we get our societal protection because we have this back-end protection of treating it in this way. And we all went into this thing agreeing that that's how we were going to treat it. The defendants know, the defense bar knows, the legislature set it up this way, the courts have approvingly treated it as such for some 35 years. So we all knew it was going to be treated as a conviction, and it's that notice of that consequence and the opportunity to be heard on it that gives us the assurance we can treat it as this.
I'm not going to argue with you. I respect your answer. What's missing here is record evidence that he knew all that. But I understand your argument that he's under constructive.
Well, but the chief left one important part out of the ARD arrangement. Part of it is a promise not to recidivate within 10 years, not to commit another DUI within 10 years. That's part of the ARD program.
Yes, it is. And that's probably the key part, is that, again, as a society, we can rely upon that protection. It's a data point that we can use in the future because they know we can use it in the future, and obviously we have important policy reasons for using that.
How is it a diversion? How is it ARD is a pretrial diversion.
Yes.
How is it a diversion if you're going to deem it a conviction?
Because that's the only consequence that comes with it after it's done. You get a reduced license suspension, you get probation light. It's not exactly the same as a bona fide probation. You don't get a conviction out of it. It's not like other states where you have to make an admission of guilt on the front end, where you have technically a conviction there and judgment of sentence is just not entered. it's an extremely favorable program for the defendant.
But I'm sorry, go ahead.
The only thing we get out of it is the protection.
Well, no, you also get the fact that the ARD defendant has to undergo some sort of a rehabilitation evaluation, an evaluation of whether or not they're an alcoholic, what their drinking problem is, or drug problem, whatever it is. Don't they also get some sort of assignment in some cases to do community service? I mean, they're individually evaluated, I believe, but I think under the diversion program, it's more than just a suspended license. There are packages created for individual defendants.
That is fair. There are some counseling obligations that come therewith.
With the community goal of public safety as well as rehabilitation.
Of course, and that's where we get into a problem down the road, is if somebody comes in and they have another DUI instance, I say another because we're counting the ARD as the first under pre-Chitchkin law. I have a 6-month maximum sentence to work with this person who has some serious substance abuse disorder issue. If it's a highest rate offense and it's treated as it was pre-Chitchkin, I have a 5-year tail. I sit on the DUI treatment court in Center County. I can get that person on my DUI treatment court. I can get them long-term counseling. I can work to evaluate the underlying issue that's bringing them there, and maybe we can fix the issue. That's no longer an option post-Chitchkin, and that's the rub on this one.
Can I ask you a follow-up? You described it as a matter of grace, undeniably true. It's totally up to the DA. But I think you also suggested, if not said outright, that it's a one-sided thing, that it's, you know, I take it that you're arguing it's just a benefit to the defendant, but certainly in the larger counties, you will acknowledge there's a significant benefit for the county to do this. I can still remember taking clients to ARD. There were a lot of these people, and if the DA has to prosecute take all these cases to trial, that's a significant number of cases. So you acknowledge there's benefits to both sides on these programs, aren't there?
As a logistical matter, yes, the volume of cases, disposing of what on their face are less serious cases till they become more with recidivism. Yes, there is a pragmatic reason for that, but the reason that we do agree to it is because we know we have the societal protection. You know, it obviously would not exist if that benefit did not come on the back end.
But you could deal, and I assume you are dealing in a post-Chitchkin world with these in whatever way you deem fit. And if you deem it necessary just to not offer ARD to DUI people, then you can do that. You have that power, right?
I think there's perhaps some question on that, but I suppose that would be an option. What we've tried to employ in Center County as a Bucks County creation is a written waiver form as to whether that has any capability of being enforceable in the future. I think it's maybe dubious at best. I think that was recently argued at the same time I argued Miraz, and the court's questions at the en banc panel would suggest it's not probably enforceable. So we've tried our best.
I don't know why it wouldn't be enforceable, but we don't get to decide that in this case because you don't have it here.
Correct, because that's not the facts of our case, sir.
So seek aliquotter on that other case.
Bucks County matter, but I will suggest that.
Counselor, correct me if I'm wrong, wasn't it this court, I believe in the 1970s, that approved the application of ARD as it is applied today?
Yeah, so it would have been imposed in 1983. The General Assembly was involved. We have an entire chapter of the Rules of Criminal Procedure designed to effectuate that legislative intent. So there was a lot of input from various branches of government in creating this structure. We all agreed for 40 years,
But we'd have
not
to
quite
admit that
40.
we're wrong of our decision that it should not be used as a conviction.
Well, I'm not going to comment on it in quite that way, but it would seem that prior iterations of this court were supportive of this program.
Counsel, I'm going to ask the same question for the appellee's counsel. Would this situation be different if Pennsylvania had adopted something called a second offense DUI? Like an actual, because there are crimes that are second offense from an M to a felony or something like that. But if there were a second offense DUI, would you be able to argue here that an ARD acceptance could give rise to a second offense DUI charge?
I'm not sure that it would be a distinction with a difference. Depending on how the statute was drafted, it would still be evaluating. I mean, it's kind of what we already have, isn't it?
Well, no, because because to get a conviction for a DUI in Pennsylvania, as it stands right now, no element of that crime is a prior offense. You just have to charge that you had a DUI. This issue we're facing with today, it comes at sentencing in the sense of, okay, well, you got convicted of this DUI, but because you had a prior conviction. I'm saying there are crimes in the crimes code that you would have to put in front of the jury the fact that they had a prior conviction because you're trying to convict them of a second offense battery or second offense something.
So you're saying if we had a jury trial right on the second offense DUI that said, as an element of the offense, ARD acceptance counts to increase.
No, I'm saying is that, no, I guess that's my question you're right, it's unfair in the sense that I'm hypothesizing what a statute is like, but you agree that there are crimes in the crimes code that specifically have a second offense this, a second offense that?
Yes.
Okay. And when you have those, you actually have to prove in front of a jury by facts the prior offense, correct?
Yes.
Okay. So I guess my point is, this isn't one of those cases. There's nothing that went to the jury in this DUI case where you had to prove the prior ARD in order to get this conviction.
That's accurate, and I would imagine the defense bar would not be very pleased if we got to present the prior DUI conduct in a subsequent DUI trial and create inherent prejudice. So, Your Honors, if I might just wrap up there, I was asked by President Judge Emeritus Bender at the Mraz matter why this matters, similar question to what Justice Donahue asked earlier in the DUI case where the police officer was hit. And why it matters here is because if Chichkin stands, if we don't prevail in our argument here today, the legislature will probably fix this. They will probably draft a structure where there would be a front-end guilty plea. They certainly have the ability to do that. But if they did, we would lose 10 years of data points of recidivism. We would have people not being appropriately recognized as recidivist DUI offenders. We would not be able to give them the treatment options we've talked about today. And because of that, people will invariably have more fatal collisions, more property damage, more personal injury that comes from this. So that's why the Commonwealth believes it matters.
Thank you very much.
I'm sorry, Chief Justice, I'm sorry. Maybe I'm the only one who didn't understand that. But I didn't.
Okay,
the parade of horribles is the legislature in a Chichkin world, assuming for the sake of argument, we leave it extant. Then the General Assembly does what? I'm sorry.
So presumably, if Chichkin holds, the structure 3806 as is unconstitutional for want of due process. They certainly have the ability to try to fix the law where we would have a probation before judgment structure similar to maybe Maryland, where you come in, you plead guilty, we put a pin in it, you do your part, and then the conviction is never entered and everything goes away. They could do that. That would satisfy a lien. It would be a good structure to accomplish that. But all of the ARD acceptances for the last 10 years under the prior structure aren't going to count towards that because there was no guilty plea. It was under the old structure of doing ARD. So we lose all those data points for enhancing recidivist DUIs, and we will have more people who are not appropriately treated because their next case that comes through is only a 6-month, not a 5-year tail. And those people are going to be more likely to go out and commit future DUI conduct.
And what are you asking us to do? What are you asking, what relief are you asking for in this case?
I am asking for you to recognize that the structure that is in place satisfies due process, both procedurally and substantively, and that the structure in place can remain.
Now, I'm only one guy, but I would tell you, go back and get and inform defendants of the consequences of the first in both the colloquy and the written colloquy that's provided. And I don't think you have a problem. All right, let's hear from Mr. Decker.
Thank you, Chief Justice. Justices, may it please the court. Mark Decker on behalf of Stephen Verbeck. First off, I agree with Chief Justice's assertion that if we had a different scenario, if there was an on-the-record colloquy, if the procedure had been done different, then we might not be here today with the case that we had before the court.
So you're talking about a guilty plea?
Well, you know, one of the things that we need as far as due process is that the defendant does have to admit or acknowledge that there were facts that they had committed. Now, what Mr. Metzger said, it might be one of those things in the future where we have to have sort of, you know, that probation before, or it's sort of like Section 17, probation without verdict, where there is an on-the-record colloquy similar to a
But
guilty
not a
plea.
guilty plea. Don't go down that path.
No, not a guilty plea, Your Honor, but in order to you know, protect the individual's procedural and substantive due
An
process rights.
acknowledgement of what this means and what it could mean if a second offense is committed. You're not arguing for a guilty plea colloquy.
Not necessarily, Your Honor, but something more than what we have, and I can assert that I practice in dozens of counties in central Pennsylvania, and in no county that I can think of do they put anything on the record regarding the facts that are supposedly had occurred.
Yeah, I just feel like you made a concession there that sort of surprised me.
I tried to undo it.
Yeah.
Well, maybe
I
I
don't think
misunderstood
that's the
the question.
concession he intended to make.
Counsel, in furtherance of both Justice Weck and Justice Todd, to make this concrete, the United States Supreme Court has decided if the consequence of a conviction is that you are, exportation is the wrong word, that you are compulsively removed from the United States. The consequence of a conviction is that we throw you out. That has to be in the colloquy because it's such a fundamental change in your life. And if it's not disclosed, then they can't enforce that. Here, I think all we're saying, and I think it inures to your benefit, is that, again, it's like any plea bargain at all. It's a contract between the defendant and the prosecution, and it's enforceable. So that you would put into the written colloquy as a plea bargain, you would put into the verbal colloquy the consequences of the first DUI used as a sentence enhancer if you get a second DUI. And if you do that, I don't see where that violates public policy. But if you don't do that, then you're falling back on this argument that we should deem it a conviction.
But that's
Is
all
that a
you
fair
need.
synthesis?
That's all you need to do.
That's all you need to do.
That I misunderstood, and I apologize for my confusion there, but I do agree with that. It would not be tantamount to a guilty plea colloquy. It would just be providing on-the-record notice of what the potential consequences would be in accepting the ARD program. So
Thank you for clarifying that.
thank you for that, Your Honors.
But again, Elaine said any fact that increases the sentence has to go to the jury for a proof beyond a reasonable doubt finding. So I guess I'm not. Are you conceding the Chief Justice's question about the public policy and that it just needs to be a discussion?
Well, not necessarily, Your Honor, Justice Weck. One of the first thing I was going to say when I got up here, but I sort of jumped on Chief Justice's last statement. A lien changed the landscape, and as we stand here right now, 3806, as it is drafted, unquestionably, in my opinion, and decisions of this court and other matters, it cannot be reconciled with a lien.
I thought that was your argument.
That is my argument.
It surprised me a little at the beginning there.
My apologies, but that is, a lien changed the landscape. As 3806 is drafted, as it stands right now, with all the process and procedures we have in place, it cannot be reconciled. It is an aggravating fact that creates a new element of a new aggravated crime where it imposes a mandatory minimum sentence. And the structure that we have in place, the procedures at the county level in a defendant accepting ARD, none of that satisfies a lien. And that is what I believe this court can confidently decide this matter on, is that 3806 is unconstitutional in that it triggers a mandatory minimum. It's, as the statutes are written, it's
Counsel.
decided by a judge and not a jury.
Counsel, a defendant is permitted to waive a plethora of constitutional rights. Is it your position through that comment that a defendant, by accepting ARD, if colloquied appropriately, is not waiving that right such that they are not entitled?
Well, I think in essence 3806 would have to be drafted or redrafted because you can't waive the right to be sentenced to an illegal statute. You can't waive the right to be illegally sentenced. For instance, if a defendant wants to avoid jail time but say, can you sentence me to 10 years of probation for a misdemeanor of the third degree, that would be a legal sentence, but that would also be a waiver, and I don't believe that that would be valid. So if that were to be the case, which it's not, we're going to need some legislative fix to this, but 3806, you can't waive the right to be sentenced under an illegal sentencing scheme, and that's what we have here with a lien. If I answered your question, but I don't believe you can.
I'm going back to basics here. Nobody forces a defendant into ARD. Defendants aren't duped into going to ARD. They go into ARD because they're trying to avoid being convicted, being found guilty, trying to avoid going to trial. That's why they do it. And I'm not sure, Aline, I'm not sure I agree with Justice Weck that, or your argument for that matter, that a lien changed the landscape here. It seemed to me that everybody is on notice that if you go into this grace program to avoid that conviction, and you recidivate within 10 years, part of the ARD is to promise, I will not do this again within 10 years. That's part of the promise. And you do it, there's got to be a consequence for breaking your promise. How does that violate any constitutional right? Especially if we start engrafting onto this idea of, this isn't even a collateral consequence. A collateral consequence happens immediately. You enter into ARD and automatically your license is suspended. This is a consequence that is contingent upon your own behavior. So notifying you of collateral consequences is one thing. Notifying you if you break your promise, something is going to happen. I just don't see why that's an alien violation.
Well, I would submit that the promise that the defendant makes and not to recidivate in the next 10 years, I don't know if that's exactly a promise that is made or anything along those lines, but none of this is spelled out. None of this is on the record. A defendant certainly does get a benefit. The Commonwealth likewise gets a benefit as well. But as far as that goes, the notice, I'll go back to mandatory minimum sentences, drug weights, school zones, things along those lines. A defendant would be presumed to be on notice to have knowledge of the statutes and the case law alike. And just because they had that notice of a statute or a potential consequence doesn't mean that potential consequence was constitutionally violated.
You weren't finished.
Isn't the answer, counsel, that Justice Brobson's scenario is not the Almendarez-Torres exception? Almendarez-Torres says prior conviction's an exception. So it would be correct if that discussion was memorialized in not just a discussion, but a guilty plea, which means a prior conviction. There you go. There's your exception. There's your Almendarez-Torres exception. But it seems that the scenario that my esteemed colleague was offering would manufacture a new exception, which I think would clearly be cert-worthy because it would be asking SCOTUS to create a new exception to a lane. Am I missing something?
No, I agree with you. And the Almendarez-Torres exception it's a conviction. The conviction that satisfies substantive and procedural due process, it's cloaked in all the constitutional protections that we have. Proof beyond a reasonable doubt, if there's a jury trial or a colloquy for a guilty plea colloquy where the defendant is on notice. So I do believe that may involve carving out another exception, which may or may not be viable. I can't tell you what the United States Supreme Court would do in that event, but what we have right here and right now is controlling law, and that's a lien. And I know I keep harping on that, and got off to a bit of a rough start there, my own fault, but 3806 cannot be reconciled with a lien. It's a new fact. It creates an aggravating circumstance.
You're arguing this in such a difficult fashion. You're the most easy of arguments. ARD is not a conviction. That's all. And you don't have the underlying question of whether or not there was an actual plea bargain here where he was told that the first DUI would serve as a sentencing enhancer for the second. He knew that. He accepted that to get an ARD. That's for the next case because they didn't do that here. So you don't have a conviction here, so you win.
No, that's correct, and that's,
And if I could just follow up on, I am so confused, Mr. Decker. You do represent the appellee, the defendant below, correct?
I do, Your Honor. I think I got bogged down in the hypotheticals in different scenarios.
Okay, let's get back to this case. You represent Mr. Verbeck.
That's correct.
He was an ARD defendant below.
He was.
Correct? And he prevailed in front of President Judge Rui in Center County, correct?
Are you talking about, this
case, yeah, he had a successful ARD. He prevailed in front of the Superior Court,
correct.
and you are the appellee here in front of us.
I am, Your Honor.
You are. And all really you should be arguing is that you want to continue to prevail, right? You want it to be affirmed, and you want us to affirm it.
I do, Your Honor, and like I said, I might have got bogged down in some of the hypotheticals and the possible scenarios of what might be or what could be, and that might not have been the right way of doing it.
I
but
was just confused, and if you're arguing that, the Superior Court be affirmed, I think I understand it.
that's what I'm saying. I do think it should be affirmed. ARD is not a conviction under any circumstances.
It's not a conviction.
It's that easy.
Thank you.
Thank you.
Any other questions? Justice Bundy? Anybody? And don't mean to cut you short, but again, we understand the case entirely. So, and you're going to win. So, thank you very much. I shouldn't say that.
We're not promising a 7-0.
I can't promise that. I'm one vote, but you got it. You think he's going to lose? We're going to take a 5-minute break so that you have the benefit of arguing to a full court. This action was filed pursuant to the whistleblower law, and the Commonwealth Court affirmed the trial court's grant of a summary judgment in favor of the defendants, holding plaintiff failed to establish a causal connection between her report of wrongdoing and her termination from employment. We granted allowance of appeal to determine whether the Commonwealth Court applied the proper legal standard for establishing a prima facie case of causal connection under the whistleblower law. So, Ms. Davis, if that's correct, please proceed to argument.
In addition to the reason you just stated for the grant of appeal, there was also a second reason stated, which was to review the facts and determine whether the law was accurately, correctly applied to this case.
Your argument was that I think that I said Superior Court, that the Commonwealth Court in its decision engaged in fact-finding. I think that's probably subsumed in the first, but feel free to present it as you see fit.
Your Honor, Your Honors, this court cries out for a determination, an explanation, a clarification of the Pennsylvania whistleblower law. The Commonwealth Court inaccurately applied the whistleblower law, and in its opinion, it replaced the words such as, which is used in the statute, with a such that. And because of that, I believe that it limited its findings. The lower court did not make findings of fact, but instantly credited the employer's reasons for termination. I think what this court should do is to go back and to look at the situation which occurred before any comments were made to the supervisor or to the district attorney. The record in this case shows that prior to March of 2015, when an argument was brought forward to, I am the appellant, I'm sorry, I didn't introduce myself. I am the appellant in this case, and I'm also acting as counsel. I was represented by attorney Kevin McKeon, who did an outstanding job before the Commonwealth Court in analyzing these facts, putting them together, and establishing a brief and arguing before the Commonwealth Court. And with that, I'm very grateful. My name is Donna Davis. I'm also the plaintiff, like I said, the appellant.
Ms. Davis, your argument's pretty simple, I think, and tell me if I'm wrong. Your argument is that there are genuine issues of material facts that need to be resolved by a jury. He said, she said, I say that when I blew the whistle on the district attorney's assistant, everything changed, resulting in my culmination. They say that's nonsense. We terminated you for cause, and you have a case that a jury should decide. Isn't that your argument?
Basically, but I think what you should do is look at two elements that weren't raised or argued, but I think it's obvious from the O'Rourke case that this court should look at the immediate retaliation that took place as one issue. And in analyzing that, this court should look at whether or not a prima facie claim was brought forward immediately after the report to the district attorney and to my supervisor. Walking out of the meeting, I was disallowed to enter a meeting with the county manager, Mr. Parston.
Stop you again. I appreciate you're a lay person trying to argue your case. You're a lawyer arguing your case. I'm sorry. So you're in pro persona?
Pro se.
But I'm not sure you are pro se, but that's neither here nor there. I get it. But we don't want to hear the facts. We want to hear the law. We know the facts. I can read them to you.
Well, the Commonwealth Court didn't know the facts, and the lower court didn't address the facts because the lower court opinion doesn't reference any facts in the record to support the four reasons that the county came up with after the litigation in this case was filed to support termination, to support a finding that The employer came up with legitimate reasons to terminate this employee. There are no facts referenced in the lower court opinion. The Commonwealth Court went beyond the facts in this case, and they felt compelled to have to introduce facts which are not part of the reasoning for the termination of this appellant. The Commonwealth Court went on to say that, well, let's look at the deposition taken of Shelby Wachilla, and let's look at the deposition taken of Nisa Gazdick. Both of them said they were uncomfortable working for the plaintiff. Well, it matters not, because that was not a reason raised by the county post-litigation. At the time of the termination, no argument was raised, no issues were given, no reasons were given to this appellant for a termination. No reasons were given until after the litigation was filed in this case, until counsel introduced themselves to this case.
The Chief Justice indicated this is an issue of standard. What do you believe the standard that should be applied to your facts?
Well, this court should look at the totality of the circumstances. It should not be limited to whether there's direct evidence that a threat was given or whether there's direction not to file a report. And I think Judge McCullough, in her dissent, adequately pointed that out. And she also adequately pointed out the fact that the only person in this case who could actually terminate anyone, County Manager Lawton, directed the district attorney in this case not to conduct an investigation that I requested be had. County Manager Lawton directed that no investigation be had in this case, and no investigation was had. From the time the complaint was made, there was never a contact made. Those are the facts in the record.
But counsel, you keep arguing the facts, but the question is the wrongdoing is the allegation of a violation of the Wiretap Act, correct?
Correct.
And the allegation of the Wiretap Act was performed by a union representative, correct?
Correct.
In operating in her capacity as a union representative.
Not necessarily. She was an employee of the county.
But
when
was
she
she
entered
there
that
as
meeting.
was she as an employee of the district attorney's office?
Yes, she
or was
was.
was she there in her capacity as a union representative?
Your Honor, I don't think you need to look at that.
I think I do, and I think you should answer the question. Because I could affirm this right for any reason and say there's no jurisdiction here because you sued the wrong party. So maybe you should answer that.
Well, Your Honor, when Ms. Schnelly was present,
was she there?
The meeting she
Was
was
she
being-
there as an associate of the district attorney's office, or there as a representative of the union? Real simple question, ma'am.
well, she was there as a representative
Thank you.
because of her position in the county as an employee of the district attorney's office. She was the elected representative. She was being paid by the county to be present in that meeting. So you cannot disassociate the fact that she was not an employee of the county. She was being paid by the county, and she was only there in her representative capacity because she was an employee of the county.
Now, the Commonwealth Court didn't get to this issue that Justice Doherty is raising. So I think, and he's absolutely right on the right for any reason thing, and this was certainly a concern that I had, that this issue, that they did not get to this issue, because I do think it's a significant issue. Union representatives are often paid by their employers to attend union events, so that's not that uncommon. The question of law here is really when you report alleged wrongdoing by someone in this circumstance that you have, is it a true whistleblower claim? And the Commonwealth Court didn't get to that question. The trial court got to that question. The trial court said, you didn't report wrongdoing, but the Commonwealth Court never got to it. So even if let's assume you're right on the primary issue that it's here on, which is, did the Commonwealth Court majority misstate or misapply the standard on summary judgment for a whistleblower claim, require some kind of smoking gun, something like that? Or was Judge McCullough right? Would you rather us get to the question of that union rep being an example of government waste or wrongdoing, or would you rather us have the Commonwealth Court look at that in the first instance?
Your Honor, I think the record is clear. Based on the definition that the Pennsylvania Supreme Court gave to public employer, it is a public employee who is being paid. So Ms. Schnelly was in her representative capacity. I think you could make that finding by your application of the law to those facts.
Justice Todd?
I don't know if Justice Brobson was finished. I didn't mean to interrupt if he wasn't. I guess the more direct question before us, though, is what may have just been a typographical error, such that if we shouldn't just reverse and remand this for the Commonwealth Court to use the right language and apply the correct standard.
Well, I think you have the authority, and it's your position as a matter of law to discuss.
I mean, isn't that really the prudent thing to do, though, and let the Commonwealth Court look at this issue and examine it under the right standard?
Your Honors, I think that this court can apply the law, in this case, to find that the law was inappropriately applied, and then to apply it to these facts.
You don't want to go, your preference is for us to get this back to the Common Pleas Court, resolve all these issues in your favor, and let you go back to the Common Pleas Court and go to trial.
Your Honor, I would like to go back to the Common Pleas Court, yes.
You don't want to make a stop at Commonwealth.
You don't want to stop at Commonwealth Court again,
Well,
which is a very nice place, by the way. Commonwealth
He's
Court is
been
a
there
very
a long
nice
time.
It used to be.
place. Nice as it used to be.
This has already been a long journey.
Certainly has.
Counsel, can I just ask one point
Yes.
for clarification? Our case law currently stands for the proposition that concrete facts outside of the subjective perception of the employee is necessary. Do you agree with that? You're not challenging that aspect of our case law,
Well, I think the law goes a little bit further than that.
which is?
I think they talk about circumstantial evidence, at least that's my interpretation,
Well,
that you should look at the total facts, which I don't think the Commonwealth Court did, and certainly the lower court didn't do that. That's why I'm raising the facts here.
Okay, but you're not arguing, and I think I'll read what I think our cases hold. Concrete facts or surrounding circumstances must be something beyond subjective perception of the employer's actions. That's our current standard for reviewing these whistleblower claims. Do you agree with that?
To a certain extent. But I think you should also look at the employer's response to determine under O'Rourke whether there is a separate, and what has not been decided yet by this court is a legitimate reason that's not pretextual. That's what I'm asking this court to do in this case, is to look at the reprisal, the retaliation, separate from the termination. The Commonwealth Court didn't do that.
I'm sorry to interrupt you, counsel. The Schnelly retaliation type issue, that is, I thought really the issue that we were here, the legal issue we were here for, is whether under the whistleblower law, direct evidence is required or whether circumstantial evidence is adequate, because the cases, as I think Justice Donahue may have suggested or somebody did, whether it's Baylitz or Golashevsky or O'Rourke, it leaves some room for doubt here. I think that's why the case was outlicotter worthy, is this question of direct versus circumstantial evidence, for purposes of summary judgment or judgment on the pleadings or what have you, seems to be the one that's at bar today, or do I have that wrong?
Your Honor, yes. You looked for direct, but you also looked for circumstantial. The purpose of the whistleblower law is to protect the whistleblower. As Judge McCullough said, it's an onerous burden to have to prove direct evidence, either of a threat or direct evidence of a threat that you'll be terminated, or a direction given not to make the report. Interestingly, though, Robert Lawton in this case gave a direction not to continue with the investigation that I asked for. So it exists. Direct evidence does exist in this case. But there's also an overwhelming amount of circumstantial evidence from the retaliation that took place immediately after the meeting with the district attorney through the termination several months later. And it's not just one incident of asking for an investigation. I repeatedly asked for the status of the investigation that I was promised, repeatedly up until 1 month before my termination. In an email, I asked for what's the status of the investigation by the Attorney General. No response. No response. Those are facts that were not placed into the record by the Commonwealth Court or by the lower court. There was just an automatic, we accept the 4 reasons that were offered by the employer for termination, and those 4 reasons were not given at any point in time. There's no damaging evidence in the record that was submitted by the employer in this case. That didn't come until they got lawyered up.
So really, we go back to a case is, 1, you want us to correct the standard that the majority had. 2, you have genuine issues of material fact that deserve to go to the jury, both as to your claim of retaliation and wrongful discharge and their claim of what you would say is pretextual basis for your termination. So those are the things that you want us. Correct the standard, and there's genuine issues of material fact that warrant going to trial.
Your Honor, and I would go a little bit further than that, and based on the retaliation claim, I would say that the employer in this case never came forward with any reasons to support the retaliation that happened for several months. There was...
Well, but that goes to the Chief's thing. You're arguing the facts. I'm trying to get to the legal, what's the legal consequence of what you're asking for? There was legal error in the Commonwealth Court in majority in terms of the evidentiary standard that you had at summary judgment. You want us to correct that. And then 2, your point being, under that new standard, there are genuine issues of material fact that require the case be allowed to remain alive.
And based under O'Rourke, I think this court could go a little bit further and return the case for a calculation of damages based on the retaliation claims.
I don't think that's going to happen.
We are focused.
Trying to get you to trial. Don't get greedy.
We are focused on the legal issues, of course, but could you just clarify for me so I have a full picture? Way back in 2015, when this whole thing started, the original incidents that you wanted to be investigated that led to all of this and the alleged retaliation and everything that happened later, the original incidents were the 2 times that you allege meetings were secretly recorded by Ms. Schnelly. Is that it, or was there something else?
That's what was brought forward later on that I learned. That there were actually 3.
3.
There were 3, but originally it was 2.
Meetings that were secretly recorded. That's the whole sum of the...
Correct, and the evidence is in the record. The lower court refuses
I don't need the whole explanation to get into the facts. I just wanted to clarify that was the subject of the investigation you requested.
Yes, and there was a good faith report. I know the lower courts made an issue of that. That's why I'm pointing to the documentary evidence in the record. All you need to do is take a look at the notes of testimony.
We will. We'll review the record.
I just wanted to make sure there wasn't something else I had missed.
Is there anything you'd like to say in conclusion? I think we understand your position.
Your Honor, I raised in my reply brief an issue with respect to defendant's counsel raising issues that are outside of the record in this case. And I'm asking the court to address those. Mr. Buffalino raised information to this court, which I think prejudices my case before this court under the Rules of Professional Conduct 3.1. Mr. Buffalino raised information about another proceeding with the intent to prejudice this case. There's disciplinary rule violations, and it's the authority of this court to address those.
Respectfully, we're not the D board. Are you saying that Mr. Buffalino is arguing facts that were not either in a pleading or in an affidavit of support of summary judgment or against it?
Your Honor, they're outside the record in this case.
All right, we'll look at that for you. Thank you. Mr. Buffalino? You might just want to respond very quickly to
Yes,
that. if you
may it
would.
please the court. Mark Buffalino on behalf of Luzerne County and the other defendants. That's sort of the cake and eat it too complaint. In both in Attorney Javitz's brief and as well as in the dissenting opinion that comes from the lower court, it quotes and relies upon in great measure the motion to dismiss opinion that was issued by Judge Mione in the United States District Court for the Middle District for the proposition that, or at least the improper suggestion, that even Judge Mione found that there was a solid basis. How, first of all, in being truthful, and second of all, in being a good lawyer, how do I not point out the fact that that motion to dismiss decision came in the pleading context, where you must accept the allegations as true? Here, we are not in the pleading context, we are in the proof context. And the case law in this Commonwealth has been, from this court and others, that you don't just get to rely on the allegations of your complaint. As Justice Donahue alluded to, the standard is that you come with concrete facts and circumstances to demonstrate that the report led to the dismissal. You have none of that here, not one single ounce of it. If you look at Attorney Javitz's brief, the appellant's brief in this case, where she talks about how she was retaliated, look at the cites. She cites to her complaint. On the opposite side, since the inception of this case, we do the complete 180-degree opposite. We cite to the record, where she says, we moved her office. After her complaint, she learned from the first time that we moved her office. Well, that's just factually not true. And I understand that Your Honors have command of the facts and don't want to belabor them, but...
Can I jump in on that? Because whether or not we have command of the facts, we are here for the law.
I was just about to say, yes.
So I'm not so sure anyone has the command of the facts, but I do think we need to look at a legal issue. My question for you at this point is, what's your position on whether or not, under the whistleblower law, a plaintiff can make out a prima facie case, a case that can survive summary judgment via circumstantial evidence alone? Is direct evidence required to survive summary judgment, or can circumstantial evidence get over that hurdle as a matter of law?
I think Goloszewski's answered that question already.
Well, what about Balintz? What did Balintz say about that?
Well, I think the answer to that question is that where you can, it can, yes. Circumstantial evidence can be the basis for which you can prevail on a whistleblower claim. However, where that circumstantial evidence is vague and inconclusive, then the answer to that is you don't get to prevail. So in other words, if we were to allow, you would never have summary judgment in any case. If we were simply to allow the plaintiff to regurgitate the allegations of their pleadings and provide self-serving statements in the evidentiary record, you would never have a summary judgment. That would be, I could just write an affidavit for myself if I'm the plaintiff, and therefore you survive and go to
I think you've
trial.
managed to sort of come back. Justice Todd felt you hadn't answered the prior question. And I think, if memory serves me, and I'd invite her to enhance this, the question was, what is it that you're relying on to determine that there's no genuine issue of material fact? Is it affirmance in your answer or new matter? Is it affidavits in support, or is it just a vitiation of what plaintiff has put forward?
Mr. Buffalino, I think you were in the middle of an answer wherein you were describing the circumstances of the termination or the alleged retaliation and the moving of the office, which was getting into the facts, which I think led Justice Weck, to interrupt you to get right into a legal issue, which we're concerned with, obviously, but I would like to hear you complete that answer.
Thank you. And I'm just not sure, since you can divorce the two from each other, since the standard is, did the plaintiff come forward with concrete facts other than just her own perception of things to see what does the record say about that? And the only person who says that happened is her. I don't believe so, Your Honor.
Could I hear what that factual dispute is?
Yes. So she claims a myriad of things. She claims that shortly after she reported to the district attorney's office the suspected, albeit mistaken, wiretapping, which we supported her on, by the way. We went with her. That we then moved her office as some sort of punishment. Her own deposition and the deposition of two other witnesses in the case make it clear that at the time she was hired, there was discussions about relocating her office. So that wasn't in retaliation for her report. That had been contemplated since the minute she walked in the door. She talked about not having access to the budget, as the HR director, not having access to the budgetary decisions. Well, she said that, but we produced, and is in the record, a myriad of email correspondences back and forth from Mr. Parsnick to her saying, what about this? What about that? She says that we stopped her from participating in union negotiations and handling AFSCME matters. We produced pages upon pages upon pages upon pages of emails showing discussions. Do this, don't do that. Tell me about this, tell me about that. We produced that stuff.
May I, and I think this is in furtherance to this precise point. What is this record? You mentioned 2 depositions. How many depositions were taken, roughly?
10, maybe?
Okay, did you take them all, or did
Every
the
one of
plaintiff take some?
No, I think maybe at the time other members of my office might have taken 1 or 2,
Oh, I'm sorry.
but I took the majority of
Did
them.
the plaintiff notice and depose some people?
Yes.
Okay, and therefore we have a record. Now, you've just said to us, in response to Justice Mundy, you know, that her claim regarding moving her office is not accurate, that her claim regarding access to the budget items is not accurate, and that her claim regarding union negation is not accurate. And I think I had the question that Justice Mundy asked you. I mean, that's all well and good, but why aren't those factual issues for a jury to determine?
Because I think Goloszewski and Evans has already, I mean, if the plaintiff could just simply regurgitate her allegations of her complaint without any concrete evidence as the case law requires, why would those cases require that? Both of those were in the summary judgment context.
Well, we'll have to look at the record, obviously, but she took some discovery, you took some discovery.
Yes.
It seems as if there's more to this record than her complaint.
Well, counsel, if I may follow up on that. I'm looking strictly at the statute 1423A, and the concept of a whistleblower is that there must be a reporting of an incident of a wrongdoing or waste by a public body. And to prove that, you then provide facts as to any type of retaliation or discrimination. Opposing counsel indicated on this record before this court that the actual wrongdoing was the alleged violation of the Wiretap Act. The summary judgment indicates that there needs to be some concrete evidence, whether it's circumstantial or not, that a wrongdoing was performed, not whether her office was moved, because that's indications of a retaliation after the initial wrongdoing. What does this record indicate as the concrete evidence of a wiretap?
0.
There you go. Okay.
There was a significant portion of this case talking about what actual evidence there was. There was a lot of, as Goloszewski talks about, personal perceptions of what might have occurred, but no actual facts.
Right. Goloszewski stands for, as Justice Donahue said, plaintiff must show by concrete facts or surrounding circumstance that the report of wrongdoing, not the retaliation or the actions which will comprise the damages, but the reporting of wrongdoing. I'm just looking because unlike my colleagues, I've read the record, I haven't seen any evidence of any concrete facts or surrounding circumstances other than the written allegation that a personal cell phone was placed upside down with her hands gently folded upon it during an interview.
I would think you're exactly right, Justice Doherty. In addition to that, I mean, there's several different prongs to this. It's not just the causation element of did we retaliate against her. It's also, was there an actual wrongdoing? Was Ms. Schnelly there? I mean, she clearly wasn't there as a member of the county. Ms. Javitz was there on behalf of the county.
But more fundamentally, not just also, but more fundamentally, was there a wrongdoing? I mean, that's the first thing we have to determine.
Yes, ma'am.
That's the question.
Yeah.
Could I follow, because Justice Doherty asked about Golishevsky. I wanted to get your reaction to the divergence between the Commonwealth Court's quotation of Golishevsky and the actual verbiage, which seems to be a distinction with a difference and not one of no moment. So specifically, the Commonwealth Court made a mistake, I'm sure inadvertent, quoting Golishevsky to the following effect: by concrete facts or surrounding circumstances that the report of wrongdoing or waste led to plaintiff's dismissal such that there was specific direction or information received, et cetera, whereas the actual text of Golishevsky provided, quote, such as that, unquote, so that speaking of providing examples of facts or circumstances rather than requirements of proof, which the wording actually used by the Commonwealth Court seems to be suggestive of proof requirements rather than examples. Can you relate to that?
Yes, I can. And I think Justice Todd got it exactly right. I think that was a Scrivener's error. When you actually look, though, I'm not even sure that it requires remand or reversal, though, because when you actually look at what the Commonwealth Court did, it didn't apply the such that. It didn't require the direct threat or the direct evidence that might be suggested by the such that language. What they actually did is they painstakingly went through all of the things that we pointed out for them in the record as a such as. We didn't move her office because she reported. We didn't exclude her. We didn't give her menial tasks. We didn't do all of the myriad of things that...
Well, isn't that fact-finding?
Excuse me?
Isn't that fact-finding?
No. No, the plaintiff...
Why wouldn't that be fact-finding? Because she disagrees with that.
I think what the Commonwealth Court was doing was applying what this court has said it has to do. It had to put the plaintiff to the burden of coming forward with concrete evidence and circumstances, facts and circumstances, to show that the reporting, that the termination had some connection to the reporting.
So when you, going back to the Common Pleas Court, when you filed your summary judgment motion, her response, obviously, this is, Rule 1, had to come forward with evidence beyond the pleadings to support her allegations. And you're saying she produced nothing.
Other than her own allegations of her complaint and her own deposition testimony.
Okay, so why is the deposition testimony not good enough? You don't have a nanny glow issue.
No, I'm not suggesting that you do. But there has to be, if you look through her deposition, saying that's what I think happened or regurgitating her allegation doesn't, in my view, constitute concrete facts and circumstances to substantiate the connection between her reporting. That's the thing. I think if we're getting caught up on the reporting too, it's not like she could have, we supported the reporting. The key has to be we terminated her because she made a report. Well, we didn't. We actually supported the report.
Well, no, because I think she's saying that the report never went anywhere. That someone was going to, that the criminal investigation that was indicated was going to happen never happened.
That's actually a perfect example. I'm sorry to interrupt you.
No, that's
actually a perfect.
If I can give you one perfect example, I'll shut up.
It's actually a perfect example of the issue here. She says that happened. Well, we deposed the district attorney of Luzerne County. We got an affidavit from the chief law enforcement officer of Luzerne County, and she said that never happened.
Well, did she turn it over to the Office of Attorney General and investigate?
She did.
And that's in the record also?
Yes, sir.
Counsel, can I ask one other question? I think part of your argument, maybe all of it, and it's probably correct in part under our existing case law, you're arguing that what she is relying on are her subjective perceptions.
Yes, Your Honor.
How about the fact that she had positive performance reviews prior to the reporting, and then she was fired?
Well, Justice Johnson,
Doesn't that fit into this category of a concrete fact? I know you're going to say that's not why she was fired, but isn't that a fact question?
it is. It's just not a material fact. So when you look at Golashevsky, when you look at Evans, when you look at O'Rourke, maybe not O'Rourke, but I think so.
O'Rourke probably supports her
But
proposition.
in each of those instances, each one of the plaintiffs in those cases, also in the summary judgment context, also had periods in their employment tenure where they were praised or lauded by their employer. But life changes. Some employees remain.
Except she was only there for a year. I mean, which is a blessing and a curse, so to speak, from a factual evidentiary perspective.
Yeah, there's no carbon cutout for how one's employee's tenure can go. Some people stay forever, never have a problem. Some people are there 3 days, and problems arise. But the problem, the fact of the matter is, and that's not a determinative factor, because if it were, the plaintiffs in Golashevsky would have prevailed, the plaintiffs in Evans would have prevailed, and this court made it very clear. Things like that is not the concrete evidence that they're looking for causal connection to the retaliation.
Was the union representative an employee of the county?
She was. She was a clerk to typist for the district attorney's office. So she would type the appeals, briefs, the memos, and things of that nature. When she's in the room with Mrs. Javitz, though, that day, she's not there as a clerk to typist. She's there as the president of the ASME union, providing shielding from the person who was there on behalf of the county, Ms. Javitz. They're not there both acting on the county. How could that be? You would not have the dual separation between the union and the management in that scenario. So the realities and the facts here have to win out, and I think they did at the trial court, and I think they did at the Commonwealth court, and I think they should here.
Thank you.
Thank you.
Surely.
Sorry, not to beat the dead horse, but if a jury,
Turn it on.
if a jury heard this case and had before them, they could choose to find that Ms. Schnelly was being paid by the county and was a county employee. And they also could find, if they chose to, that there was a recording that was in violation of the Wiretap Act. And if a jury did find those two things, would that be sufficient for a wrongdoing for a whistleblower claim?
No. And here's why, respectfully, Your Honor. First of all, I'm not sure that the jury could make the legal determination that she was an employee of the county. I probably would put up a pretty stiff fight to make that a question for the trial judge. But even if that did manage to make its way through the 5-hole, even if you were to find that Mrs. Schnelly was the most serial wiretapper this planet has ever seen, it makes no difference. We didn't fire her because of that. If we were so upset about her reporting this to the DA, why did we go with her?
But that's not my question. My question wasn't if you fired because of that, but whether that would be a wrongdoing for the purpose of the whistleblower statute.
Yes, it could be, but there are ands in the whistleblower statute. It's that it's a public report, a report of wrongdoing by a public body that caused her, that led to her termination. So you can get by the first three prongs, but you can never get over on the fourth one.
Can I ask one more question?
Yes, Justice.
What if she was wrong that it was wiretapped?
Well, she was wrong. Yeah.
But reporting an honestly held belief that there was a wiretap violation, is that not protected
Absolutely
by the Whistleblower
protected.
Act? Okay.
Absolutely protected.
Thank you. Got it.
We're not disputing that.
Okay, thank you.
Thank you, Mr. Aplt. No, we do not have rebuttal in the court. Thank you very much.
That concludes our argument. We understand the case. We'll take it under advisement and we'll issue a ruling. Brian, will you call the next case? Please, ma'am.
Matt, throw that in there.
All right, in this direct appeal from the Commonwealth Court, we granted argument to consider, oral argument to consider whether appellant's class action petition stated a viable claim that Act 12 of 2019, which eliminated general cash assistance and amended statutes relating to health care revenue and related programs, was enacted in violation of original purpose and single subject, which are Article 3, Sections 1 and 3 of our Constitution. And if that's relatively correct, please proceed.
Thank you very much, and good afternoon, Mr. Chief Justice, Honorable Justices. My name is Mary Pat Pileggi, and I represent the 12,000 Pennsylvanians who were receiving general assistance, cash assistance, before it was eliminated in 2019 by Act 12. Act 12 made several changes. I'd like to highlight just two of those changes for you at the top of my presentation today. First, it eliminated the general assistance, cash assistance, a small $200 a month grant provided to not just low-income people, but no-income people. These are people who have no income, have no other source of income, cannot work because they are disabled, or they are fleeing domestic violence, or they are in drug or alcohol rehabilitation. At the other end of the spectrum, we have Act 12's expansion of the permissible uses of hundreds of millions of dollars of federal funds in the city of Philadelphia to fund a broad array of programs, including things like restaurant inspections. So imagine your favorite restaurant here in Center City, Philadelphia. What does the inspection of that restaurant, so it can keep its doors open to its clientele, what does that have to do with a disabled person with no income who now does not even have enough money to buy a roll of toilet paper, let alone buy a meal at that restaurant? What do these two very divergent topics have in common? That's what we've spent 3 years litigating here in this case. Commonwealth Court has concluded that medical assistance is the thing that ties these two very divergent topics together. The Commonwealth Court reached that conclusion even though the Department of Human Services itself admits, and I quote here, quote, "General assistance, medical assistance is not affected by Act 12. So somehow the Commonwealth Court concluded that medical assistance is the single subject of Act 12, even though the department itself admits that Act 12 eliminated the cash assistance program but did not change the medical assistance program at all. The Commonwealth Court does not explain this. Indeed, they cannot, because not only does the elimination of general assistance, cash assistance have nothing to do with restaurant inspections, it also has nothing to do with the medical assistance program. The medical assistance program and the cash assistance program are two separate and distinct programs. Medical assistance provides health care to low-income people through payments made directly to medical providers in amounts that the Department of Human Services sets. Cash assistance, on the other hand, provide very small $200 monthly grants so that people have cash in their own pockets so they can purchase things like toilet paper at market prices.
You're
from that
using
cash
those
in
as synonyms, general assistance and cash assistance.
I am not. So there is a general assistance cash assistance program, and there's a general assistance medical assistance program, and they're very different.
What your complaint is about is general assistance, cash assistance.
Absolutely, yes. And the cash assistance program is quite specific. It is specifically for people who do not have income, and their need for that cash assistance is directly tied to their complete lack of income and their inability to purchase things like toilet paper.
You know, Counsel,
Yes.
if we were a legislative body and we were considering this, we might have decided opposite of what the Pennsylvania legislature did. But that, as you understand, that's not our function. We're not a policy-making body. We're a court. So the wisdom of the elimination of cash assistance is simply not before us. Turn your attention, if you would, to single subject or original purpose.
Absolutely.
And specifically why. And let me ask you in furtherance of that. I actually took the time to read the final act. Sort of gobbledygook, but I plowed through it. Where in it, and I don't mean to ask you an unfair question. If you don't know, then that's why we have good law clerks. But where in it does it mention restaurant inspections? Because I just don't recall that from my reading.
So Section 7 of the statute, if you take a look there, adds the word "and public health programs" into the permissible uses of these federal funds in the city of Philadelphia. Before Act 12, it just said that Philadelphia could use those funds at public health clinics, which do, in fact, primarily serve low-income people. Act 12 expanded that to also include public health programs, and public health programs in the city of Philadelphia include things like animal control and childhood literacy and restaurant inspections.
Thank you very much.
Restaurant inspections? Any restaurant inspections?
That's my understanding.
But restaurant inspections is not, those words do not appear.
Those words do not appear in the statute. It just permits the city of Philadelphia to use those funds for things like restaurant inspections.
And again, that's in the record, or is that a matter of judicial notice? That's what a public program is. I do see the words "in public program" added here.
Right. That is in our petition, it is in the record, and the Department of Human Services has admitted that there are no disputes of fact in this case.
And the term of art is public health program? Or
Public health program is the actual word in the statute.
Okay. Could you clarify one other thing before you zone in on your legal argument as to single subject?
Yeah.
The medical assistance portion that's paid directly to hospitals, does it benefit more than indigent people? Does it benefit you and benefit me?
Absolutely. So
and how does that work?
So the assessments are taxes on just about every hospital across the state. And in the city of Philadelphia, if you look at that same section of the statute we were just looking at, the assessments apply to not just hospitals that disproportionately serve Medicaid patients, but also to all general acute hospitals.
It goes
in the
into
city.
their general pot? It doesn't go in a pipe that directly serves the indigent?
It does not. So it does eventually end up in higher Medicaid reimbursement rates to the hospital, but then the hospital can use that money to to improve care for the entire Medicaid, the entire hospital's population of patients.
But would a hospital that's serving more Medicaid patients have a greater chance of getting that money or get a greater amount of that money?
I suppose the more Medicaid patients you have, the more of that money you will end up getting. Okay. But the hospital can then use that money to fund the hospital at large.
Thank you.
Yes. So to turn to your question, Mr. Chief Justice, about single subject.
Although you have certainly alluded to it in terms of restaurants and general population of hospitals, feel free to expand.
Yeah. So, and it has proven very difficult for any court to identify the single subject in a way that could possibly meet Article 3 standards. This court in December 2019, in its decision on a denial of a preliminary injunction, suggested that the single subject of Act 12 could potentially be the provision of benefits pertaining to the basic necessities of life to certain low-income individuals. This suggested topic is so broad that it could encompass not only every benefits program that the Department of Human Services administers, but also programs administered at the Department of Aging and the Department of Health, the Public Utility Commission. I mean, if this is an acceptable single subject, you could have one bill that covers pharmaceutical coverage for the elderly and payments to child care centers and nutritional support for breastfeeding women. I mean, the list goes on and on. Electric utility rates. I'm sorry, I couldn't hear you.
I said at least we don't have turnpike paving and casinos in this bill, right?
I think, are you referring to Page?
I'm just making a comment.
Well, I mean, even with Page, that had some relationship to gambling, right, and gaming. Here, what we have, this is actually much closer to, I think, the City of Philadelphia case, where one of the things that that bill attempted to regulate was the convention center. Now, the convention center sits in the City of Philadelphia. It's kind of surrounded by Philadelphia things. It kind of looks and feels like it might be a Philadelphia thing. In this case, cash assistance is the analogy to the convention center. It sits within the middle of the Department of Human Services. It sits within the middle of this bill that's all kind of about health things. But cash assistance is not health care. People cannot buy toilet paper with their health insurance cards.
May I ask you, if the legislature passed a statute that eliminated cash assistance, and I know it's the elimination that is odious to you, and also enhanced medical services to the poor. So we take away the cash, we give them enhanced medical services, and that's all the statute did. Would that satisfy single subject?
I don't think so, Your Honor. So, and it's important to note that the cash assistance, the general assistance cash assistance program was originated in the Depression era. So we have, these two programs have existed running along side by side with both cash assistance and the medical assistance program existing together for many, many decades. The other thing to note here is just the medical assistance population is huge. 3.5 million people are currently getting medical assistance. Because it's so big, they are very economically diverse. So it could include Social Security retirees who are getting $2,000 a month. It can include young, healthy people who are working and earning $15 an hour at a part-time job. The cash assistance population that we're talking about here, it is very different to be no income than it is to be low income. If you have no income and you cannot work, you are going to be stuck in that no income position for a very long time. They have no other source of income available to them.
But does that, in your view, violate single subject? That it would encompass both no income and low income people? I mean, you have to give, you don't have to. We have to give some deference and leeway to the legislature.
Yeah. So it's not just the cash assistance part that is so far outside of the single subject. It is also those restaurant inspections, right? Go ahead.
Counsel, if I may, following up on that, I've been listening to you, and I'm sympathetic, but I have a question. Since we know that you're permitted under single subject to have a broad association, Medicaid, general assistance, cash assistance, it's all for low-income people, whether they can afford to roll toilet paper or they can afford a pack of Newport. Why isn't that permissible if it's all with regard to low-income people? And the monies being received by Philadelphia is to medically assist our poor in the city.
So just to correct one thing there, the monies received in Philadelphia are used to fund everybody, or used to benefit everybody in Philadelphia, not just low-income people. And I think that's the other end here. So you have problems at both ends of the spectrum.
Counsel, I have to stop you there. Insurance for other people. Medicaid and Medicare will prevent the other Philadelphians. You're not telling me that this bill would provide those with insurance the benefits of not having insurance? I'm confused. Why don't you share with me how you articulate that the money's coming to the Philadelphia region benefits everyone?
Sure. So the amendments to House Bill 33, which eventually became Act 12, included the Philadelphia hospital assessment and the expansion of the uses in the city of Philadelphia. Those provisions were all about taxes and revenue. Act 12 expanded those permissible uses of federal revenue in Philadelphia. The department characterizes these benefits to the public as a whole as ancillary benefits to the public at large. But these were Act 12 affirmatively expanded the uses of these federal funds to not just focus on low-income people, but to benefit the public at large.
At Philadelphia, for which we are the largest, poorest city in the country.
Yes,
Let's
but
take that into consideration in concept of a reasonably broad purpose. Sorry?
In the country or the state?
Yeah.
Okay, but it's not just the city of Philadelphia, it's every hospital across the state receives the benefits of these assessments, these increased payments to
Speaking of
hospitals.
hospitals, I asked a number of questions in my dissent at the last stage of this, and I didn't see answers on remand here to any of my questions. And the first of them was, who are the quote certain low-income individuals unquote benefited by the various hospital assessments and incentives? Did the Commonwealth Court majority give us any answer to that question?
I did not see an answer to that question.
So there's no satisfaction, counsel, is there, of the single subject rule or the original purpose in that regard, is there?
I do not believe so. And since you brought up original purpose, I certainly do not want to skip over that. This court made it very clear in that 2019 decision that the original purpose of House Bill 33 was to eliminate general assistance, cash assistance, and we of course agree with that wholeheartedly. The amendments to House Bill 33 had a very different purpose. So what the legislature set out to do with House Bill 33 was to eliminate cash assistance. So they set out to move these general assistance, cash assistance folks from that very large low-income group and stick them in the no-income group. And remember that once general assistance, cash assistance folks get there, they stay there. So the legislature set out to lock these folks into long-term and complete destitution. The amendments, on the other hand, the legislature had a very different purpose with those, right? Every single entity affected by those amendments benefited. So the hospitals are getting paid more. The city of Philadelphia has more leeway in how they use their federal revenue. The state can balance its budget, right? The general assistance, cash assistance folks were the only folks who lost out, and they didn't just lose out a little. They were catastrophically harmed by this bill.
But regardless of, I'm sorry to interrupt you, counsel, but I want to make sure this is directed correctly. Regardless of whether it's catastrophic or wonderful, I mean, that's not for us. The merits of it, the wisdom of the legislature is not for us. The question is the constitutionality, and that's why I asked you a moment ago about the questions I asked in my dissent. The majority sent it back, and now here we are again. Yeah. And I'm perceiving no connection between the hospital assessments and the cash assistance for these certain low-income individuals. Was any supplied?
No, there were none supplied. There were no explanations supplied. And I can conceive of no possible purpose that could tie these two very divergent legislative goals together.
Well, even more worrisome, or as worrisome, is there was no notice of it in its title. And maybe that's important, maybe it's not, but to the extent a title is supposed to give notice as to what is contained within the bill, there's nothing to indicate that cash assistance is, there's nothing to indicate what happened to general assistance, cash assistance in the bill.
Absolutely, and I think that's kind of the root cause of a lot of the confusion here and why Commonwealth Court was never able to actually grasp that cash assistance, what it means in this bill. And on this point, I think it's very important to keep in mind that Act 12 was drafted in direct response to this court's decision in 2018 in Washington versus Department of Public Welfare. In that decision, the court put the legislature on notice that a bill that both eliminates general assistance, cash assistance, and includes taxes on medical providers like nursing homes or hospitals is likely to fail in Article 3, Section 3 analysis, but the legislature did it anyway. Now we have, yet again, Act 12 that both eliminates general assistance, cash assistance, and that has these revenue tax provisions on medical providers. And they went a step further, and they gave it a deceptive title, to your point.
A little bit about that title issue?
Absolutely.
And talk about the title issue and whether it's important.
Yes, so the legislature gets the Washington decision. They have Act 80 in their hands. And what they did was they copied and pasted the statutory provisions from Act 80 right into Act 12, but they didn't copy and paste the title. Act 80 had a very clear and quite explicit title, if I can find it, but it said very clearly that it would call for the cessation of the general assistance, cash assistance program, while also maintaining the general assistance, medical assistance programs exactly as they were. That was right in the title. But they didn't copy and paste that title. They
Would
changed it.
that be a common purpose, unifying subject in your estimation? To eliminate the cash assistance and then whatever you said to maintain the medical assistance?
That's what we decided in 2018.
Right.
Um,
No, but I'm asking you, would that be all right?
Not to Act 12, because Act 12 does much more than either one of those
That's the
things.
problem, right?
Yes.
In Act 12, I think it says, not specifically, but that its purpose is to codify the public welfare laws of the Commonwealth. And that's so broad as to be meaningless.
It is
In your view, is that
very,
fair?
very broad, and I think it would violate Washington in addition
Right.
to other cases.
But if she could just finish her answer, with respect to the title, the new title of Act 12, there's no notice whatsoever about the cessation of the payments of the general assistance cash assistance.
Not only is there no notice about the cessation of those payments, there's no notice that the bill does anything to general assistance, cash assistance at all. The cash assistance program is not mentioned.
And does that matter? I mean, don't we presume that the legislators who are voting on bills read the whole bill? I mean, why does that matter?
So the Article 3 requires the legislature to act deliberately and in accountability to the public. This, of course, is important to the legislators to have a notice that gives them to have a title that gives them notice about what's in a bill, but it's also important so that the public knows what the legislature is planning.
Well, and the Constitution actually says
And the
shall be
Constitution
clearly
actually
expressed in its title.
There is that.
Absolutely.
There is that, yeah. Okay, thank you.
But sure.
Yes, Justice Mundy. Please.
I apologize, Justice Mundy.
That's fine. I'm just, to my understanding, the only issue not decided by weeks 1 was the deceptive title component of this appeal. And because that claim was raised for the first time in your amended petition, is it preserved for this court today?
Well, I believe that it is, because it was raised by Commonwealth Court and Commonwealth Court ruled on it, and this is a direct appeal on the court's approval of the department's preliminary objections.
Okay. And then when you look at Article 3, Section 1, can you indicate what language of that section that delineates information with regard to the bill's title?
So there is nothing in Article 3, Section 1 specifically, but there is in Article 3, Section 3, and this court's jurisprudence on Article 3, Section 1 states that when the court is looking for an original purpose, the second prong of that process is to look at the title and contents of the bill to see if that is deceptive.
So I see in Section 3 there is a requirement that the bill's single subject be clearly expressed, but I'm just teasing out a difference in the terminology clearly expressed as opposed to a deception or a non-deception title, which I think that you have expressed here in the courtroom.
Yeah, and I will admit the court's jurisprudence on this it does sometimes lump these two together, right, with clear title and deceptive title. But I think it is clear from that jurisprudence that what we're looking for here is a title that would not mislead a reasonable person into believing that the contents of the bill are anything other than what they are. And because this title does not mention cash assistance at all, any reasonable reader would have no reason to believe that the bill had anything to do with cash.
Is it your position that the requirement pertains to the subject of the bill or its contents?
I think that Article 3, Section 3 would require that the subject be clearly expressed in its title, and that Article 3, Section 1 would require that there's no deception between the title and the contents of the bill.
All right, may I I'm looking at the title of the bill, and by skipping again the surplusage in it, it says it's to revise public welfare laws for general assistance related to categorically needy. Why doesn't that subsume the cash assistance question?
Yes, so general assistance, categorically needy medical assistance is different than general assistance, cash assistance. And I think it's important here
It goes on, so again, just that, so the question's clear. And again, this is the title of the act, so I'm sure you have it there and can look at it. It says, revise public welfare laws for general assistance dash related to the category needy, which is what I asked you about. And then it says, and medically needy, only medical of eligibility assistance.
Yeah,
But
so-
but
I'm sorry.
prior to the conjunction and is the term general assistance for the categorically needy. And my question is, why doesn't that subsume the cash assistance issue you're concerned with?
Okay, thank you for the question. And I'm glad you asked it because it is confusing. The general assistance, there are two general assistance medical assistance programs. One is called General Assistance Related Categorically Needy Medical Assistance, and the other is called General Assistance Related Medically Needy Only Medical Assistance. So there are two different medical assistance programs, and this title of this bill refers only to the medical assistance programs, not to the General Assistance Cash Assistance Program.
And may I follow up?
Yes.
Because I don't think the chief got to the latter part that was added by the committee and that then passed, which added the following language to the title, quote, and for medical assistance payments for institutional care in hospital assessments, further providing for definitions for authorization for administration, no hold harmless, for tax exemption, and for time period, and in statewide quality care assessment, further providing for definitions. There's a bit more that was added on. Is that not correct?
Absolutely. And what we have seen the legislature do now twice is pile on the enormous financial and political might of hospitals and nursing homes and the city of Philadelphia and the entire federal Medicaid program to swallow up this relatively teeny tiny and quite frail general assistance, cash assistance program. If this program is ever to have any hope of true access to a deliberative and accountable legislative process, we need Article 3 to work for these folks.
Ms. Pileggi, could you address the whole purpose behind our single subject jurisprudence in terms of log rolling, and why, if this deletion of cash assistance payments, general assistance, cash assistance is so bad, why on earth did the governor sign the bill?
So one of the things that Article 3 was designed to protect was the governor's veto. And the governor was quite clear that he supported the general assistance, cash assistance, and he wanted it to stay. So when the legislature added the enormous financial and political might of all of these very powerful institutions into this bill, they really tied the governor's hands. He called it a Hobson's choice that he had to make. In order to protect his constitutionally protected right to that veto, but also to protect his constituents, including general assistance, cash assistance recipients, rights for him to stand up for them, Article 3 requires the legislature to offer him a bill with a single subject, because there is no line item veto in these bills. And so that if he makes that choice, that policy choice for himself, he can go forward with that veto without the Hobson's choice.
So he could not have accomplished all this good in the medical assistance arena and all this good for hospitals and Medicaid recipients if he had not agreed to cut cash assistance. That was the only way he could get it all done, because they were all shoved together in this bill.
Absolutely. And also I would add on to that, to the state's need to balance its own budget. The legislature was quite clear that that was one of their main goals with these amendments.
And that's the very definition of log rolling, isn't it?
I believe it is.
What has changed between our decision in weeks 1 until today, such that we would revisit our holding in that case that these were all provisions of basic life necessities to certain low-income individuals that was a valid unifying topic?
So the December 2019 decision was a decision about a preliminary injunction. So the standard of review, of course, was very different. That was a highly deferential, abuse of discretion standard of review. The standard of review today is the opposite of that. In addition, we have an amended petition for the court to review, and we have 3 years of briefing where both parties have had an opportunity to respond to the court's December 2019 decision and to fully develop their legal arguments.
Has anything changed in the bill, the language of the bill?
Absolutely not, no.
Thank you very much. We'll hear from opposing counsel.
Good afternoon, Chief Justice, Justices. May it please the Court, my name is Frank Tamulonis, excuse me, and I represent the Apelli, the Department of Human Services in this matter. Since this Court's majority opinion nearly 3 years ago, appellants have had an opportunity.
Could you pull the microphone up? I believe you're slightly taller than Ms. Pileggi.
Is that better? Okay. Since this Court's majority opinion nearly 3 years ago, the appellants have had the opportunity to submit and file an amended petition, and they've also had the opportunity to argue the merits of this case before the Commonwealth Court. Notwithstanding those additional opportunities, the outcome there before the Commonwealth Court was the same as the outcome before this Court. The Commonwealth Court twice accepted this Court's majority opinion and twice rejected appellants' constitutional arguments. We're now back before the Court on largely the same facts and the same legal arguments. There's one notable difference, however, which is that we are not on a review of a denial of a preliminary injunction. And thus, the question is not whether the appellees have raised any substantial question regarding the merits of this case. Rather, the appellants have the much heavier burden of showing that the legislative process leading to the enactment of Act 12 clearly, plainly, and palpably violated the Constitution, with any doubt being resolved in favor of constitutionality.
Can you answer this then, counsel? How do the hospital assessments and incentives benefit the class of people who are receiving cash benefits prior to Act 12?
So, Your Honor, and I do intend to address this throughout my argument, but to directly address your question, the test is not whether or not there is a single beneficiary. The test is not whether the hospital assessments benefit this group and the cash assessments assessments benefit another group. Rather, the applicable tests with respect to both original purpose and single subject is intent and subject. So,
what's the subject? Okay, no bill shall be passed containing more than one subject, which shall be clearly expressed in its title. That's section 3. Tell me how this satisfies that.
So with respect to the amendments to Act 12, and there were multiple provisions within the Human Services Code that were amended, those related to nursing home incentive payments, statewide quality care assessments, as you mentioned, as well as the Philadelphia hospital assessments. Now, each of the assessments, it's essentially a tax. I think I agree with the appellants in generally their description of what this is. It's a tax that generates revenue. It creates money that then goes and serves hospitals that serve high volume Medicaid populations. And it also, in addition to that, releases...
I hate to interrupt you, but right there, I think it's important. Does it serve high-volume Medicaid patients, or does it serve all patients, as I think your opposing counsel said?
It certainly goes to the hospital, but it goes to those hospitals because they have high Medicaid populations. So, and again, I think I agree with Ms. Pledgy that the more Medicaid patients that the hospital serves, the more money that hospital will get.
Which it's free to use as it likes.
I believe that's correct, Your Honor.
Go proceed, please.
In addition, the hospital assessments free up federal matching dollars, Medicaid matching dollars that are served for the same purpose. Now, the overarching goal of the assessments, Your Honor, is to ensure medical care for low-income individuals. So that, we believe, is under the same single subject as the original provisions of the bill, which address general assistance.
Well, counsel, let me follow up on that, but on Article 3, Section 1, the original purpose. As we know, our Page decision gave a two-pronged analysis.
Correct.
When you apply the two-pronged analysis to determine when we're looking at its purpose, the concept of purpose, how do you argue to us that when we consider the original purpose with the final purpose, that in the final form, it's not deceptive?
I'm sorry, you said it's not
in the final form, it is not deceptive considering exactly what you're arguing. It was originated as to remove cash assistance for the incredibly poor. And now we're increasing hospital assessments, and tangentially, poor will benefit, but so will others.
So, and let me begin by addressing that the way the appellants have addressed that, which is that the crux of their argument, as well as the amici's argument, is that Act 12 was enacted initially for the sole intention to eliminate cash assistance, such that any additional provisions that are put into the bill must singularly relate to the elimination of cash assistance. This view is an overly rigid view of Article 3, and it must fail for two reasons. First of all, the argument that the original bill only eliminated cash assistance, it's true to the extent that cash assistance was eliminated, but it's also woefully incomplete. And if you look at the original bill at printer's number 47, it consisted of 4 sections that sought 3 objectives, the first of which is eliminating cash assistance. But at the same time, it sought to reenact and continue general assistance, medical assistance. And lastly, it sought to make further revisions and definitions to clarify that general assistance, medical assistance, was continuing. The net effect of those 4 sections was that general assistance was limited, to medical assistance only. And I would direct...
So let's freeze right there. Let's take that. So the original purpose was to eliminate cash assistance and restrict general assistance.
Yes.
Despite that not helping poor people. So we have that as our original purpose. Now go on with the final version with the expansion of the assessments.
If I can just continue to address the original purpose there, Your Honor, I want to point you to the legislative history, and in particular, the committee bill summary, which provides notice to lawmakers of the bill's contents and purposes. It expressly acknowledged these multiple objectives, and it stated, and I quote, HB 33 eliminates the General Assistance Cash Assistance Program on July 1st, 2019. The bill also provides for the continuation of the GA-related categorically needy medical assistance program and the General Assistance Medical Assistance Program for the medically needy only. So the problem here, however, is that the appellants focused only on one section of the original bill, Section 2A.
The bill didn't do anything. It just said we're not going to crush the medically needy as opposed to devastatingly poor. That's what that said.
I think what it shows is the intent of the legislature to do two things. One, yes, eliminate cash assistance, but at the same time continue medical assistance. There were multiple intents to the original bill, and the purpose was not to just eliminate cash assistance. It was not just to continue medical assistance.
So fair enough. Following on your argument, if we're maintaining medical assistance, tell me in the original, the final purpose with the expansion of the hospital assessment, how is that limiting medical assistance? To me, that's expanding it, which would be somewhat deceptive.
Well, and the single purpose, or the original purpose, and the single subject that we put forward has nothing to do with limiting, Your Honor. The single subject that we believe applies here, and the original purpose, is that each of these provisions amends existing sections of the Human Services Code pertaining to health care relating to low-income individuals. That's the common thread. That was the original purpose.
12,000 general assistance cash recipients that started the case, and that has nothing to do at all with the hospital assessments. How is that linking up with your single subject and original purpose argument?
The single subject and original purpose is they both deal with the provision of health care to low-income individuals. So let me back up for a second.
I'm sorry to interrupt you, but just on that point,
What about the cash assistance?
there's no overlap, or is there overlap, with the cash assistance without the medical component?
I would disagree with that. I believe that there is overlap. General assistance, backing up just a step, does contain two different portions. There's the medical assistance, which we've already discussed, and then there's cash assistance, which you're pointing out right now. Now, there have been arguments here that cash assistance has nothing to do with health care, and I think that that's belied by the record. And if you look at the amended petition, and if you look at the declarations attached thereto, it notes that health care, or that cash provided to low-income individuals could be used for health care related issues. For example, making co-payments on prescription
Yeah, but
drugs.
you're taking it away from them, so they can't use it for toilet paper or health care.
Well, and again, the purpose and the subject is that we are taking away, the legislature is taking away on one hand, but it's giving on the other. And what links the two is that they're both related to health care issues for low-income individuals.
That's a far-fetched argument to me, because that $200 could be spent for a bologna sandwich or toilet paper or, a myriad of things other than health care. But I apologize. Go ahead.
Is the bologna accidental?
No, I'm in furtherance of Justice Todd. In all seriousness, there's no restriction on how you spend cash assistance, is there?
I would agree with that. There's no restrictions, and yet on the facts of this case and taking them as true, we know that the money was used for health care related issues, including prescription drugs, over-the-counter drugs, personal hygiene, transportation to and from doctor's appointments. And then I would acknowledge that, yes, it could also be used for other basic necessities, including food,
You use
paid
as
utility bills.
as the recipient likes.
Correct.
If the recipient wants to go down to the local tavern and drink it away, there's nothing in the law that prohibits that.
Counsel,
Yes.
one can be an armchair political scientist and understand that this bill was passed as described by the governor as a Hobson choice, because the only way you're going to eliminate cash assistance is somehow to benefit those who depend on cash assistance or constituency, which we all know is Philadelphia, and Philadelphia lobbied to get their hospital assessments for the $1 million influx. We have that. But that's not our decision. Our decision, as Justice Brobson indicated in the prior case, is a constitutional dimension here. So I'm asking you, so that we remove ourselves from the politic and just look at it from a legalistic perspective. We know the standard is that you can have a reasonably broad purpose. And is it that your argument, as you define the reasonably broad purpose, is quote-unquote health care to low income? Because I'm trying to,
Yes.
that's what you said. But in looking at this, looking at Section 1 and Section 1 and 3 of Article 3, that's the reasonably broad purpose that you're asking us to digest and accept. Health care for low-income people.
Yes, and what I'm asking you to reject is that the original purpose was solely to eliminate cash assistance, as the appellants would suggest that you do.
What was the health care for low-income people? The fact that one thing would remain general medical assistance?
Yes, the fact that both programs, the elimination of one program but the continuation of another program, both programs relate to health care issues for low-income individuals.
How is the deprivation of income and the support of health care for low income? I'm struggling with that.
How does it?
You're saying the original purpose. You're saying don't be taken by the red herring of the no toilet paper, because this bill also includes health care concerns. Not that we're taking away, nor are we adding, we're just saying it can continue. Now, if that is the fundamental precept or the reasonably broad purpose, tell me or convince us how taking away someone's cash assistance with no link to health care is linked to health care.
Well, I do disagree that there's no link to healthcare whatsoever, for the reasons that we just discussed, that the money can and in fact was, based on these facts, used for healthcare related purposes.
$250, you can't get a premium.
So, but with respect to the original purpose, we're not saying that the original purpose was to either give or take away benefits. We're saying the original purpose was to revise existing provisions of the Human Services Code that relate to healthcare for low-income individuals. Now, this court, in its majority opinion, suggested a slightly different purpose than that, and it's suggested that the bill as a whole relates to the provision of benefits pertaining to basic necessities of life to low-income individuals, which I believe would still pass muster. Certainly, that overall topic.
Say that again, what you just said, what the purpose could be.
So the majority opinion stated that the original bill as a whole relates to the provision of benefits pertaining to the basic necessities of life to certain low-income individuals. So that purpose, that topic, is at least as narrow and perhaps even more narrow than other topics that were found to pass muster by this court. For example,
the certain low-income individuals that former Chief Justice Saylor mentioned in weeks 1 there, how are those certain low-income individuals tied in with a later added provision dealing with hospital assessments relating to hospitals statewide, for the rich, for the poor, for every kind of Pennsylvania?
so with respect to the hospital assessments, it does generate money that goes to hospitals that serve low-income individuals throughout the state. Now, one point, Pardon me?
All kinds of individuals.
Well, and that's one point that was brought up by the appellants, is that there could be other beneficiaries beyond just low-income individuals.
There are other beneficiaries.
And my response to that, Your Honors, is that it misses the point of the test. The test is not whether or not there was a single beneficiary or group of beneficiaries. The test is what is the intent of the bill and what is the subject matter of the bill. So what I believe the appellants did is they, in recognizing that the bill was changed to allow for public health programs to be included, is they went to the City Department of Health webpage and found any possible public health program that could potentially receive funding. And they picked one, including the restaurants, and said that this ruins the single subject. I would just
Well, rehabilitate that then. The public health programs, the intent of including public health programs
Right.
was what?
So those public health programs could include programs like community education campaigns, tobacco use, obesity, air pollution monitoring,
What does that have to do with
lead
helping the
remediation.
indigent, serving the indigents?
So I would just, setting aside the speculative nature of those allegations, again, the argument misses the mark because it applies the wrong test. It's not who.
Wait. How does that apply to your single subject of serving indigents' healthcare needs? What you just described?
And so what I would say is that I would submit that such programs, as we just described, do benefit low-income populations in Philadelphia through health and safety awareness programs. But even accepting as true that there might be others that benefit, if it might further benefit the general public, that does not change the intent and the purpose of the assessment.
Counsel, I'm struggling with this. If we're to amend the code, the benefits that you are describing are no better than incidental benefits, not the purpose. So how do you justify that? Am I making sense to you? You're indicating that the assessments, and it could benefit clean air and
Obesity training.
You could be very rich and very fat. The two often go together. But that being said, I'm really concerned about the single purpose, the single subject in the original purpose, when we're talking about an amendment to the health code with incidentals as opposed to a purpose, a singular purpose, even with a reasonably broad understanding.
And I think I just want to flip that, Your Honor. The purpose, the intended purpose of, for example, the assessments is the hospitals, to help the hospitals that serve high Medicaid populations. Now, the fact that there could be other benefits to the general population, as the appellants surmise, doesn't change that subject. It doesn't change that intent. And as a matter of policy, it shouldn't automatically render an act unconstitutional just because there could be other beneficiaries beyond the intended or targeted beneficiaries.
Counsel, if we could go back for a moment to the original purpose. Sure. As I understand your argument, you're rejecting the notion that the original purpose was solely to discontinue cash benefit payments.
That's correct, Your Honor.
Okay. If the legislature's original statement of the purpose did not include the language regarding the maintenance of medical assistance, would anything have changed? Would anything have changed? Suppose that the bill just ended with to eliminate cash benefits. Let's just say that's where it stopped. That's
You're saying that that's the title or the purpose of
and
it?
that's the purpose of it. It's the purpose of it. Would medical assistance benefits have changed?
They could have, and part of that is because the two programs are sort of inextricably linked under the General Assistance Program. And so the concern here, and this is the intent of the General Assembly, was to, yes, while one, eliminate cash assistance on one hand, they did not want to eliminate medical assistance on the other.
My question to you is, would it have been eliminated? would medical assistance have been eliminated for recipients of cash benefits
I believe.
without the remainder of the original bill and its purpose?
Without the other clarifications that were made within the bill, all the other sections of the original bill, sections 1, section 3, section 4, without those, I believe, yes, it could have been an unintended consequence. So therefore,
Yeah, that's what I'm trying. I'm trying to just determine, for purposes of my understanding and your argument, whether or not the additional purpose, the additional language regarding medical assistance was mere surplus language.
understood your, no, it was not, because it reflects the clear intent. It's the second decision that was made by the legislature. So there was the initial decision to eliminate cash assistance, but there was the further decision to keep medical assistance, and all that additional language, all those other sections were necessary to effectuate that purpose. Now, what appellants have done is they've ignored all that other language and they focused solely on 2A, which is what eliminates cash assistance, and they said that is the original purpose. And what we're saying is, no, there were multiple purposes and there's other sections here, and viewed reasonably broadly, that is way too narrow, and it violates the Pennsylvania precedent on the subject.
Okay, just one more time, and if you could just, and maybe you can't do this, maybe you can't do it, but could you explain to us specifically what would have changed for the receipt of medical assistance with the elimination of cash assistance? What specifically would have resulted from the elimination of cash benefits in terms of medical assistance payments?
I'm not sure I understand the question you're asking.
Well, you're telling me that they had to have that language included because otherwise something bad would have happened to the receipt of medical assistance to the former cash assistance recipients. And I'm asking you, where would we find where that would have happened? I mean, what statute tied the existence of medical assistance to the receipt of cash benefits?
It's not a separate statute. It's that the definitions under the General Assistance Program were so intertwined with each other that there needed to be clarifications within those definitions. And so if you look at Section 1 and Section 3 of the original bill, it's making those clarifications.
I'm asking you, so you're telling me to look at all of the definitions in the statute regarding medical assistance and cash assistance, and it's going to be obvious that the elimination of cash assistance was going to impact the receipt of medical assistance.
And I realize that it is not an easy bill to read and that the definitions are complicated, but without, what I'm saying is...
I could understand complications. I'm asking you right now if you could tell me what they are. I mean, I'm just trying to get over the possibility that the language regarding medical assistance payments was nothing more than surplus language in the original bill. But I guess I'll have to look at the definition.
Yeah, Your Honor, and I apologize. I don't have the full act or the amendments in front of me.
On Justice
May I-
Kennedy's question.
You may.
Briefly, Chief. My understanding is that the original bill, HB 33 PN 47, made 3 substantive changes to the Public Welfare Code. 1, created a definition of general assistance related categorically needy medical assistance. 2, terminated the cash assistance program. And 3, deleted the provision of the welfare code that classified an individual as medically needy if the person received the cash benefit. So, I wanted to ask you that question in relation to the original purpose. How then does the juxtaposition of that original purpose with all of this later language avoid a manifestation of impermissible log rolling?
So, first of all, with respect to the argument on log rolling, I just wanted to make a couple quick points. First is that the subjective intents of individual lawmakers is not properly for consideration on an Article 3 argument. In fact, if you look at the city of Philadelphia, it indicates that the proper scope of review is strictly the original bill, the later bill, and then the legislative history there too. The city of Philadelphia also provides a definition for log rolling, which states that log rolling is the combining of several distinct matters which would not pass in their own right, but combining them to ensure passage. So as a predicate to have log rolling, you have to have distinct matters. Where, however, there is a common thread, where all of the provisions fit within, are sufficiently cohesive that they fit within a single subject, there is no log rolling. And that's notwithstanding the fact that a particular lawmaker may or may not unanimously agree with all the provisions in a bill. So I'm not sure if I quite got to your question there.
I don't think I asked you about any individual lawmaker. I do think it's germane that the governor made it clear the Hobson's choice point my colleagues asked you about earlier, but I'll stop there.
You want to comment? Last comment, I think we're done. But when the governor, we have a pretty strong public policy against log rolling. When the governor characterizes the bill as compelling his signature to get the monies to the hospital, notwithstanding that he hates to eliminate cash assistance, it sounds like a log roll to me.
Your Honor, clearly the governor agreed with some topics, but not all topics. But again, as City of Philadelphia teaches us.
Just because I want to finish. The governor agrees to some, not all. If they're in separate bills, the governor can veto one and sign one. So the legislative design, and I'm not accusing anybody of any malevolence, but legislative design is to give the governor what he really wants and sneak in what he doesn't want. And again, it's a law school example of a log roll.
If I may just conclude by making one final point, Your Honors. The case in Page teaches us that the underlying intent of Article 3 is twofold. First, it's to ensure an open and deliberative legislative process that provides reasonable notice of a bill's purpose. And second, to prevent deceit and stealth legislation through the attachment of riders and concealing the purpose of the law. Here, the appellants have not set forth a single allegation that any individual acted with any deceitful intent, or that any lawmaker or anyone else was actually deceived as to the purpose and contents of the bill. In fact, I would direct you to paragraphs 40 through 57 of the amended petition, which show that Act 12 and its contents were well advertised, were robustly and sometimes contentiously debated, showing that deliberation could and did proceed with circumspection. I would note that Act 12 did not contain any
One
riders.
last phrase, please. We got the case. We understand it.
Okay.
It's a difficult case, but
So with that, in light of the standard and the presumption, I ask that the court uphold the decision of the Commonwealth Court. Thank you.
Very well argued by both sides. Very well argued.